Legal Developments, Deep Dive, February 11, 2026. Legal Developments, Deep Dive, February 11, 2026. To provide an overview, the following table summarizes each topic, including the jurisdiction, key legal issue, the court or authority involved, and potential implications. Topic: Jurisdiction. Key legal issue. Court/body involved. Potential implications. Execution of Ronald P. Heath, stay denied, execution carried out. Florida, state case, and U.S. Death penalty appeal, stay of execution, Eighth Amendment and procedural claims, unanimous jury, clemency, etc. Florida Supreme Court, U.S. Supreme Court. Affirms continued enforcement of capital punishment. SCOTUS's denial signals high bar for last-minute stays. Precedent holds no unanimity required for death sentence. Could embolden states like Florida pursuing rapid executions, raising debate on due process and execution protocols. Pending SCOTUS case, parental notification, transgender student policy. California and U.S. federal. Parent rights versus student privacy when a minor adopts a new name/pronouns at school. First Amendment, religious exercise, and 14th Amendment, parental due process, versus equal protection and privacy for LGBTQ students. U.S. Supreme Court, interim docket, 9th Circle State District Court injunction. A pivotal church and state and parental rights case. A ruling for parents could require schools nationwide to inform parents or allow opt-outs on gender/pronoun issues, potentially undermining student confidentiality policies, Politico.com. A ruling for the state would uphold protections for transgender youth in schools, reinforcing student privacy and anti-discrimination measures. Ninth Circuit on TPS termination, Honduras, Nepal, Nicaragua. United States, immigration. Executive authority on immigration versus APA limits. Lawfulness of abruptly ending temporary protected status for long resident migrants, including claims of APA violation and discrimination. U.S. Court of Appeals, 9th Circuit, 3-judge panel stay, lower court, ND-Cal, had enjoined termination. By allowing TPS termination to proceed, the court signals deference to executive immigration policy, Yahoo.com. 60,000 plus migrants face loss of legal status, risking deportation, law.ucla.edu. Citing Supreme Court shadow docket precedents, e.g. on TPS for Venezuelans, Yahoo.com, the decision highlights how interim Supreme Court orders guide lower courts. Puts pressure on Congress to address long-term TPS holders' status and underscores the impact of the Supreme Court's emergency rulings on immigration policy. Kerala High Court, a corporal punishment case. India, Kerala. Legality of mild corporal punishment in schools. Interpretation of Bharatiya Nyaya Sanhita Section 118(1), Dangerous Weapons, and Juvenile Justice Act Section 75, Cruelty to Children, in context of a teacher caning a student. High Court of Kerala, single judge. Clarifies that reasonable corporal discipline by teachers in loco parentis can be lawful, onmanorma.com. A cane is not a dangerous weapon per se, onmanorma.com, and discipline without malice or injury isn't criminal. This ruling may influence school discipline policies in India. It reassures teachers of some discretion but also reinforces limits, no excessive force or malicious intent. It has spurred discussion on child rights versus traditional disciplinary practices, likely prompting calls for clearer guidelines and teacher training to prevent abuse. Elk Grove traffic collision, February 11, 2026. California, state law. Liability and legal fallout of a highway accident. Potential negligence, insurance claims, and any criminal liability, if DUI or gross negligence involved. California Highway Patrol, investigation, civil courts if lawsuits filed. Civil liability will hinge on fault, an at-fault driver can be liable for injuries and damages. California uses comparative negligence. Injured victims may file personal injury suits for compensation. Insurance claims are expected. Disputes over fault or coverage could lead to litigation or settlement negotiations. If serious wrongdoing, e.g. DUI, reckless driving, caused the crash, criminal charges, like DUI or vehicular manslaughter, could ensue. The incident underscores the legal process after accidents, police reports as evidence, cashlegal.com, insurance duties, and the potential need for civil suits if insurance is inadequate or contested. Justice Ketanji Brown Jackson's comments on deliberation, tariff case. United States, U.S. Supreme Court. Judicial transparency and timing, explaining why complex decisions, e.g. on tariff policy, take time. Balancing thorough deliberation versus public pressure for quick decisions. U.S. Supreme Court, Justice's public remarks in media. Jackson's statement highlights the court's commitment to careful, methodical decision-making, yahoo.com. It has two implications. 1. Public expectations. It educates the public that nuanced cases, such as those involving tariffs and trade law, may require extensive analysis, thus managing expectations for delayed rulings. 2. Judicial transparency. By openly discussing the court's internal process, thoroughly consider issues, striving for clear determinations, she adds a measure of transparency and trust in the court's work. Her comments implicitly contrast the slow, reasoned merits process with the faster shadow docket, assuring that important decisions aren't rushed. This could bolster public confidence that even politically sensitive cases, like tariffs affecting national policy, will be decided on legal merits rather than haste. Justice Alito on Scalia's legacy, wrote to Dobbs. United States, U.S. Supreme Court. Jurisprudential influence over time, Scalia's originalist philosophy and its role in overturning Roe v. Wade. Reflections on the continuity from Scalia's era to the current court's decisions, e.g. Dobbs. Perspective of a U.S. Supreme Court Justice, Alito interview in Politico. Demonstrates how a justice's long-term influence can shape landmark outcomes. Scalia's persistent critiques of Roe, often in dissent, laid the groundwork that the Dobbs majority, authored by Alito, would later use to reverse that precedent, yahoo.com. Alito's view that Scalia started so much and would approve of Dobbs underscores the through line from originalist legal theories to contemporary rulings. He also notes Scalia would be appalled by today's polarized climate, Politico.com, reflecting concern about the court's perception and the politicization of judicial debates. These insights suggest the current conservative majority sees itself as fulfilling Scalia's constitutional vision, while also navigating a more contentious social environment. Below is a detailed analysis of each development. 1. U.S. Supreme Court denial of stay in Ronald Palmer Heath execution, Florida. What happened? The U.S. Supreme Court denied a last-minute stay of execution for Florida death row inmate Ronald Palmer Heath, who was convicted of a 1989 murder, thereby allowing Florida to carry out his execution on February 10, 2026. Hours after the denial, Heath was executed by lethal injection, becoming the second person executed in the United States in 2026 and the first in Florida that year. The per curiam denial came without a published opinion, indicating that a majority of the justices saw no sufficient grounds to halt the execution at the 11th hour. This outcome followed the Florida Supreme Court's refusal a week earlier to grant relief, as that court dismissed Heath's final appeals and also refused to stay the execution. Yahoo.com. Heath's legal claims. In his final appeals, Heath's attorneys raised multiple arguments challenging the lawfulness of the execution. They contended that Florida failed to follow its own execution protocols and that the state's rushed schedule of executions risked procedural errors and Eighth Amendment violations, noting Florida's unusually high pace of 19 executions in 2025. Heath also argued that Florida's clemency process was applied unfairly, denying him due process, and that his brain development had been stunted by incarceration as a youth, potentially mitigating his culpability. One focal claim was that his death sentence was constitutionally flawed because the jury's recommendation for death was not unanimous. The vote was 10-2. Florida is among the few states that have allowed non-unanimous jury recommendations in capital cases. Heath's counsel pointed to the lack of jury unanimity as contrary to evolving standards of decency and in tension with a line of cases requiring heightened reliability in death penalty verdicts. Yahoo.com, Flcourtsm, courts.gov. Why the courts rejected the stay. Both the Florida Supreme Court and the U.S. Supreme Court found Heath's arguments insufficient. The Florida Supreme Court ruled on February 3, 2026 that all of Heath's claims either were procedurally barred or failed on the merits. Notably, regarding the non-unanimous jury issue, the Florida court cited its recent decision in Dilbeck v. State, 2023, reaffirming that the Supreme Court's precedent establishes that the Eighth Amendment does not require a unanimous jury recommendation of death. In other words, despite the U.S. Supreme Court's 2016 ruling in Hurst v. Florida, which struck down Florida's old capital sentencing scheme for giving judges too much power, neither the U.S. nor Florida Supreme Courts interpret the Eighth Amendment as mandating a 12-0 jury vote for death sentences going forward. Florida's legislature had amended the law posters to require unanimity at the time, but later, in 2023, relaxed the requirement to 8-4. However, Heath's sentence became final decades ago, in 1995, and courts have held that newer sentencing standards do not retroactively reopen such old cases. The Florida Supreme Court also rejected Heath's challenge to the state's execution protocol and clemency process, finding no evidence that any deviations rose to the level of an unconstitutional, cruel and unusual punishment or a due process violation. The court noted that Heath had litigated and lost multiple post-conviction claims over the years, exhausting his legal remedies. After this unequivocal decision by Florida's highest court, Heath petitioned the U.S. Supreme Court, but the justices declined relief, with no dissents noted. Flcourtsm, courts.gov, Flcourtsm, courts.gov, Flcourtsm, courts.gov. Legal precedent and implications. The U.S. Supreme Court's refusal to stay Heath's execution is consistent with its recent pattern of reluctance to intervene in state capital punishment cases absent clear proof of a constitutional violation, for example, a substantial claim of actual innocence or incompetence. Here, Heath's claims, involving procedural issues and non-unanimous jury sentencing, did not convince the court to deviate from precedent upholding Florida's processes. In Jones v. Mississippi, 2021, the Supreme Court emphasized the primacy of state discretion in sentencing minors to life without parole. By analogy, the court's action in Heath suggests deference to state criminal judgments when all appeals have run their course. Furthermore, the handling of the jury unanimity issue reflects the court's stance that a jury's advisory recommendation is not constitutionally required to be unanimous so long as the jury, unanimously, found the defendant eligible for the death penalty, a principle that Florida's courts, citing U.S. Supreme Court jurisprudence, have embraced. The outcome reinforces that the current Supreme Court will not act as a court of last resort to routinely second-guess state death sentences. This sends a signal that states like Florida, which recently increased the pace of executions and even lowered the jury vote threshold for new death sentences, have a green light unless a clear constitutional line is crossed. Florida's governor had signed a record number of death warrants in the prior year, nearly 4 times more executions in 2025 than any other state, part of a broader national trend of some states accelerating executions. The failure of Heath's appeals, despite arguments about rushed procedures and non-unanimous juries, may embolden such states to continue aggressive use of capital punishment. On the other hand, the case highlights ongoing debates about execution protocols and fairness. Dissenting voices, including the Florida Conference of Catholic Bishops, which urged clemency for Heath, argue that the push to expedite executions can lead to casual indifference to potential constitutional errors. In sum, the Heath case exemplifies the judiciary's current approach, a strong reluctance to interfere with state-imposed death sentences in the final stages, even as questions of procedural justice and evolving standards persist in public discourse. Yahoo.com. 2. California's transgender student parental notification policy, pending Supreme Court case. Background: a contentious California state law, enacted in 2024, prohibits public school officials from informing parents if a student asks to use a different name or pronouns at school, or otherwise discloses a gender identity or sexual orientation different from what's in school records. The law was a response to several local school districts adopting forced outing policies that would have required notifying parents of such student choices. California's legislature, backed by Governor Gavin Newsom, barred this practice statewide, citing the need to protect transgender and LGBTQ+ youth from potential harm if they are involuntarily outed at home. The law contains an exception permitting disclosure in compelling circumstances, e.g. imminent safety issues, but critics argue that exception is too vague. Politico.com. The legal challenge: in late 2025, a group of parents, represented by the Thomas More Society, a conservative Catholic legal organization, sued to block California's law on the grounds that it violates their constitutional rights. They argue that preventing parents from knowing about such a fundamental aspect of their child's life infringes on parental rights and their freedom to raise their children in line with their religious beliefs. Essentially, they contend that parents have a right, grounded in the 14th Amendment, which protects the care, custody, and control of one's children, to be informed of and involved in decisions about a child's gender identity. Moreover, they frame it as a First Amendment issue. Many of the challenger parents have religious objections to the concept of gender transition, and they claim the law forces them to remain unaware and thus unable to guide their child according to their faith, a burden on their free exercise of religion. Politico.com, Politico.com, Politico.com. In December 2025, U.S. District Judge Roger Benitez, in San Diego, agreed with the challengers in part. Judge Benitez issued a preliminary injunction on December 22, 2025, preventing enforcement of the key provisions of the law for the plaintiffs. He held that parents have a right to receive gender identity information and teachers have a right to provide accurate information about a child's gender identity, finding that the California law likely violated parents' constitutional rights. Notably, Judge Benitez carved out an exemption allowing parents with religious objections to opt their children out of the law's non-disclosure requirement, effectively permitting those parents to be notified if their child is using a different name or pronoun at school. Politico.com. Current status: at the Supreme Court, the Ninth Circuit Court of Appeals swiftly intervened at California's request. A three-judge panel of the Ninth Circuit temporarily stayed Judge Benitez's injunction, first pausing it, and then on appeal putting it on hold until the court can fully hear the case. This means the California law remains in effect statewide for now. Schools are still barred from parental notification in most circumstances. The challengers have treated the Ninth Circuit stay as an emergency situation and have now petitioned the U.S. Supreme Court to lift the stay and reinstate Judge Benitez's ruling. In early January 2026, they filed an emergency application to the Supreme Court, arguing that the Ninth Circuit's action was an extreme infringement on parents' rights. Politico.com. The case has landed on the Supreme Court's shadow docket, meaning the court can decide whether to grant or deny immediate relief without full briefing or oral argument. As of February 11, 2026, no decision had yet been announced, but the court could rule at any time. The next date the justices were scheduled to issue orders or opinions was February 20, 2026, leading to speculation that a ruling on this matter might come by then if not sooner. Yahoo.com. Legal arguments and context. This case sits at the intersection of parental rights, religious freedom, and LGBTQ student rights. The parents challenging the law lean heavily on a recent Supreme Court precedent, Mahmoud v. Taylor, decided June 27, 2025. In Mahmoud, the Supreme Court in a 6-3 decision sided with parents who wanted to opt their children out of a public school's LGBTQ inclusive curriculum on religious grounds. The conservative majority in that case, opinion by Justice Alito, held that exposure to ideas violating the parents' religious beliefs, without an option to opt out, can constitute a burden on free exercise, and it required the school to accommodate those parents. The Thomas More Society is invoking Mahmoud as a direct parallel. If parents have a right to opt out of certain lessons that conflict with their faith, they argue, parents should also have a right to opt in to knowledge about their own child's asserted gender identity, especially when their faith teaches them that gender transitions are harmful or immoral. They contend that not informing parents effectively forces the child to live a life at school that the parents are kept ignorant of, undermining the parents' ability to instruct and care for their child consistent with their beliefs. Politico.com, en.wikipedia.org, en.wikipedia.org, Politico.com, Politico.com. On the other side, California, led by Attorney General Rob Bonta, defends the law as a necessary protection for students. The state emphasizes the privacy and safety rights of transgender and gender nonconforming youth, arguing that mandatory disclosure to parents could lead to bullying at home, loss of support, or even abuse for some students. California asserts that the law does not infringe parents' general rights to direct their children's upbringing. Parents remain free to discuss gender identity with their children, but the school's duty of confidentiality in this narrow area serves a compelling interest in protecting minor students. The state also notes that the law still permits disclosure if there is a compelling need, such as a threat of self-harm. Essentially, California's argument is that teachers and schools' obligation to keep a student's gender status confidential, absent consent, is part of creating a safe educational environment, and that the Constitution does not guarantee parents access to every detail of a child's school life, especially where disclosure might endanger the child. They liken it to confidentiality that schools maintain for student counseling sessions or sensitive health information, which has been recognized in some contexts. Politico.com. This battle also raises a free speech issue in a tangential way. The California law prohibits teachers from outing students, effectively compelling teachers to withhold information. Some teachers, and the parents they support, argue this gags them from speaking truthfully to parents. However, since teachers are public employees, their speech in the course of their duties is generally considered government speech that can be regulated by their employer. Thus, the stronger claims legally are the parents' rights claims rather than the teacher's speech rights. Potential outcomes: the Supreme Court's decision on the emergency application will either let the law remain in force during litigation or block it. If the court denies the emergency relief, California's law will stay effective at least until the Ninth Circuit, and possibly the Supreme Court later, rules on the merits. That would be seen as the court not finding an urgent, irreparable harm and leaving the law in place for now, perhaps signaling that a majority is not convinced the challengers have a likely win. Alternatively, the Supreme Court could grant relief and reinstate the district court's injunction. That would immediately allow schools to notify parents, at least those who opt out on religious grounds, while the case proceeds, and it might foreshadow the court's willingness to ultimately strike down the law. Such a move would be celebrated by parental rights advocates but seen as a setback for LGBTQ protections. In the long term, if this case reaches the Supreme Court on the merits, it could become a landmark decision delineating the scope of parental rights in public education. Until recently, courts often held that public schools could introduce curricula and policies without providing opt-outs for parents, except in narrow situations. But the court's trajectory in Mahmoud and related cases suggests a jurisprudence increasingly sympathetic to parental religious and speech rights. A broad ruling against California could require school districts nationwide to accommodate parents who object to LGBT-related policies, potentially clashing with anti-discrimination principles. Conversely, if California prevails, it would affirm states' ability to implement measures aimed at protecting vulnerable student populations even when parents object, confirming some limit to parental control in the school setting. Either way, the case highlights a deepening national debate. Where is the line between a parent's right to know and direct their child's upbringing, and a student's right to privacy and self-expression in matters of gender and sexuality? The Supreme Court's handling of this issue, even at the interim stage, will be closely watched. In the words of one legal commentator, the court is effectively deciding whether policies seen by some as gender secrecy are an unconstitutional intrusion on parental authority or a necessary shield for students in an era of intense culture wars. 3. Ninth Circuit upholds ending temporary protected status, TPS, for migrants from Nepal, Honduras, and Nicaragua. The ruling, on February 9, 2026, a three-judge panel of the U.S. Court of Appeals for the Ninth Circuit cleared the way for the termination of temporary protected status, TPS, for over 60,000 longtime U.S. residents from Honduras, Nepal, and Nicaragua. The panel granted an emergency stay of a lower court's decision that had previously blocked the federal government from ending TPS for those countries. In practical terms, the Ninth Circuit stay allows the Department of Homeland Security to proceed with canceling TPS designations for those nations, at least pending the outcome of the ongoing appeal. TPS termination means that nationals of these countries who have lived and worked in the U.S. legally, in many cases for decades, under the TPS program could lose their protection from deportation and their work authorization as soon as the stay took effect. Yahoo.com, gmla.com. Background on TPS. Temporary Protected Status is a humanitarian program created by federal law, the Immigration Act of 1990, that grants temporary relief from deportation and work permits to foreign nationals already in the U.S. when their home countries experience armed conflict, natural disasters, or other extraordinary conditions. TPS is typically designated by the Department of Homeland Security, DHS, for 6 to 18 months and can be extended repeatedly. Beneficiaries often live in the U.S. for many years under successive extensions. In this case, Honduras and Nicaragua were first given TPS in 1999, after Hurricane Mitch, and Nepal in 2015, after a major earthquake. Many holders have U.S. citizen children and deep roots in American communities. In 2018, the Trump administration announced plans to terminate TPS for several countries, arguing the original conditions had improved. This prompted lawsuits. A group of TPS holders and their families sued, in a case known as Ramos v. Nielsen, to stop the termination of TPS for El Salvador, Nicaragua, Sudan, and Haiti, claiming the decision was arbitrary and motivated by discrimination. A federal judge in California issued a nationwide injunction in 2018 blocking those terminations. That case was on appeal when the presidential administration changed in 2021. The Biden administration then kept TPS in place for those countries, effectively mooting part of the dispute. However, TPS for Honduras and Nepal, and later Nicaragua, were addressed in a related case filed in 2019, Otterai v. Nielsen, which had been on hold during settlement talks. Fast forward to 2025, with the new, second, Trump administration in office, DHS Under Secretary Kristi Noem renewed efforts to end TPS for certain countries, including Honduras, Nepal, and Nicaragua, many of the same beneficiaries as in the prior cases. This prompted a fresh lawsuit, National TPS Alliance vs. Noem, sometimes called NTPSA2, on behalf of TPS holders from those nations. law.ucla.edu. Lower court's findings. On December 31, 2025, a federal district court, Northern District of California, ruled in favor of the plaintiffs, finding the TPS termination unlawful. The district judge held that the administration's decision was likely arbitrary and capricious under the Administrative Procedure Act, APA, for example, by disregarding the country's ongoing conditions and instead following a predetermined political agenda to dismantle TPS. Evidence had been presented that the terminations were driven by anti-immigrant animus or predetermined outcomes, rather than careful analysis of conditions on the ground. The suit also alleged a violation of the Fifth Amendment due to alleged racial bias, given statements by officials about Latin American and Nepali immigrants. The district court issued a final order blocking DHS from terminating TPS for those three countries, effectively extending TPS protections for the affected migrants. TPS holders from Honduras, Nicaragua, and Nepal celebrated the decision delivered on New Year's Eve 2025, as it briefly assured them of continued legal status and work authorization. law.ucla.edu. The Ninth Circuit's emergency stay. The government, Trump administration, immediately sought emergency relief from the Ninth Circuit. On February 9, 2026, a Ninth Circuit panel stayed, i.e., put on hold, the district court's ruling. This stay did not contain a full written opinion, it was an unsigned order, but it effectively sided with the government's position temporarily. The panel's short order pointedly cited prior U.S. Supreme Court orders on the interim, shadow, docket dealing with similar issues. In particular, it referenced Supreme Court orders that had allowed the government to implement TPS terminations for Venezuelan nationals pending appeal. "We are not writing on a blank slate," the Ninth Circuit panel wrote, noting that we have been admonished that the Supreme Court stay orders must inform future decisions. This is a remarkable nod to the influence of the Supreme Court's emergency rulings. The Ninth Circuit essentially recognized that the High Court's prior actions signaled how similar disputes should be handled at the interim stage. The Supreme Court's conservative majority has, in recent years, been willing to grant stays allowing government policies, including controversial immigration policies, to proceed pending appeal, even if a lower court found them unlawful. By invoking those precedents, the Ninth Circuit indicated that the same logic applied here, that the government's decision to end TPS should not be halted by a trial judge's ruling while appeals are ongoing. gmla.com, yahoo.com, yahoo.com, yahoo.com. As a result of the stay, TPS protections for Honduran, Nicaraguan, and Nepalese nationals were immediately in jeopardy once more. Their employment authorization documents, EADs, which had been automatically extended by the injunction, could now expire, and DHS announced it would update online guidance to reflect that TPS for those countries is slated to end, urging holders to make preparations. Many of these individuals have lived in the U.S. for 20-plus years, some have U.S. citizen children, mortgages, and businesses. The stay brought deep concern and uncertainty to those communities. One plaintiff, a nursing assistant who came to the U.S. as a toddler, said, "I belong here. I am upset that the court is allowing these blatantly illegal government decisions to go into effect. We will not stop fighting for justice." Advocacy groups like the National TPS Alliance decried the decision for turning their backs on people who have called the U.S. home for decades, including many essential workers hailed as heroes during the COVID-19 pandemic. gmla.com, law.ucla.edu. Legal basis and Supreme Court precedents. The Ninth Circuit's ultimate decision on the merits, and any Supreme Court review, will likely turn on how much deference is owed to the executive branch in making TPS determinations. Under the Immigration and Nationality Act, the executive has broad discretion to designate and terminate TPS. Courts have historically been reluctant to second-guess such decisions unless there is a clear violation of the APA or Constitution. The plaintiffs argue there was an APA violation, failure to consider facts, reliance on prejudice, similar to how the Supreme Court in Department of Homeland Security v. Regents of University of California, 2020, overturned the termination of DACA for being arbitrary. However, the Ninth Circuit's reference to Supreme Court stay orders regarding TPS for Venezuelans suggests that the higher courts may view TPS terminations as within the president's foreign affairs and immigration powers, not readily subject to injunction. Indeed, the Supreme Court in other contexts, e.g., Trump v. Hawaii, 2018, upholding the travel ban, has signaled that courts should not intrude on executive immigration policy decisions, especially those justified on country conditions or national security. It's also noteworthy that the Ninth Circuit's stay was issued by a three-judge panel that apparently did not weigh the usual stay factors in depth, likelihood of success on the merits, irreparable harm, etc., but rather deferred to the Supreme Court's implied guidance. Dissenting voices, such as ACLU attorneys for the TPS holders, criticized the panel for decline to consider the harm their decision would inflict and for overriding a carefully reasoned district court decision without a full review of the merits. They argue this undermines the normal appellate process and demonstrates the outsized influence of the Supreme Court's shadow docket. law.ucla.edu, law.ucla.edu. What's next and implications? The TPS case will continue through the Ninth Circuit, likely an expedited briefing on the merits of the appeal. Meanwhile, unless the Supreme Court intervenes differently, TPS for the three countries could expire. This means tens of thousands of people become undocumented and subject to deportation, although in practice the administration may stagger enforcement. The situation places political pressure on Congress to act. Advocates are urging Congress to create a path to residency for long-term TPS holders or, at minimum, to extend TPS legislatively. So far, such efforts have stalled in a divided Congress. law.ucla.edu. This episode also illustrates how the Supreme Court's conservative shift has real-time effects on immigration policy. Even without a final Supreme Court ruling, the lower courts got the message that the current Supreme Court is likely to favor the executive's authority to revoke humanitarian protections. The invocation of the Venezuelan TPS shadow docket orders demonstrates a new form of precedent. Signals from the Supreme Court's emergency rulings are effectively shaping outcomes before a case is fully decided. This has raised concerns about the shadow docket, decisions made without full briefing or transparency, effectively deciding issues of enormous consequence, in this instance, uprooting communities who have lived in the U.S. for decades. Critics argue it short-circuits the usual deliberative process. Defenders of the court's approach contend that the executive branch must be able to enforce its policies while litigation proceeds, especially on immigration matters where nationwide injunctions can tie the government's hands. In summary, the Ninth Circuit's TPS decision underscores the judiciary's current deference to executive immigration decisions and may foreshadow the eventual outcome. Unless Congress intervenes or the Supreme Court changes course, the termination of TPS for these countries is likely to stand. For the 60,000 affected migrants, many of whom are deeply integrated into American life, this legal battle is literally about the right to remain in the country. As of now, that right is in peril, pending a final resolution of the case. 4. Kerala High Court, corporal punishment ruling in India. The case, in a significant ruling from India, the High Court of Kerala held that minimum or reasonable corporal punishment by a teacher is not automatically a criminal offense, quashing a case against a schoolteacher who had been accused of injuring a student with a cane. The decision, delivered by Justice C. Pradeep Kumar on February 11, 2026, examined the scope of two laws: 1. Section 118(1) of the Bharatiya Nyaya Sanhita, BNS, a provision of the new Indian Penal Code dealing with causing hurt with dangerous weapons, and 2. Section 75 of the Juvenile Justice, Care and Protection of Children, Act, which penalizes cruelty to children. The court concluded that the teacher's act of caning a student's buttocks for discipline did not meet the threshold of a crime under either provision, given the mild nature of the force and the context of discipline.
onmanorma.com.
Facts of the incident. The case arose from a February 10, 2025 incident at a school in Tiruvananthapuram, the capital of Kerala state. A 36-year-old teacher was accused of striking a student, reportedly a minor boy, with a thin cane on the student's buttocks inside the staff room as a punishment for misbehavior. The student was taken to a local health center complaining of pain, but a medical examination found no visible injury. The doctor's certificate noted no external injuries. Despite the lack of physical injury, police registered a first information report, criminal complaint, on February 13, 2025, leading to charges against the teacher under BNS Section 118(1), voluntarily causing hurt by dangerous weapons or means, and JJX Section 75, cruelty to a child.
onmanorma.com.
Court's legal reasoning. The High Court carefully analyzed whether the teacher's conduct fell within these penal provisions. On BNS Section 118(1), this section criminalizes causing hurt using a dangerous weapon or means. The court observed that not every object used to inflict discipline can be deemed a dangerous weapon. It depends on the inherent nature of the object and manner of use. A slim cane used for educational discipline, the judge held, is not a dangerous weapon in the context of this law. The statute is meant for knives, guns, or inherently lethal weapons. A cane, in contrast, is a common disciplinary tool that is not designed to cause grave injury. Thus, the charge under Section 118(1) was untenable.
onmanorma.com.
On JJX Section 75, cruelty to child. This law punishes anyone in charge of a child who assaults, abandons, abuses, or willfully neglects the child in a manner likely to cause unnecessary mental or physical suffering. The High Court emphasized the importance of intent and malice. It cited precedent, including a case called Jomi v. State of Kerala, for the proposition that a schoolteacher has authority to correct a pupil, akin to a parent's authority, so long as the action is taken bona fide for the child's improvement and not to cause harm. The court reasoned that when parents send children to school, they implicitly consent to reasonable disciplinary control by teachers. Therefore, a teacher's corporal punishment must be examined in context. Was it done in good faith to correct the child, or out of anger/ill will to injure? In this case, the evidence showed the teacher administered a light caning with the aim of enforcing discipline, and there was no evidence of any guilty intention to harm or cruelty. The lack of injury supported the view that it was a minimal, corrective action. As such, the court held that continuing a criminal prosecution here would amount to an abuse of legal process.
onmanorma.com.
Outcome, finding the charges legally unsustainable, Justice Pradeep Kumar quashed the criminal case against the teacher.
All proceedings in the trial court were terminated.
The court effectively drew a legal line. Minimum corporal punishment administered bona fide by a teacher is not per se illegal or criminal. However, implicit in the judgment is that more severe punishment or punishment inflicted with malicious intent would be treated differently.
onmanorma.com. This ruling must be understood against the backdrop of Indian law and societal norms.
India's Right to Education Act, 2009, bans corporal punishment in schools as a policy matter, and guidelines from education authorities discourage it.
However, these are often enforced unevenly.
Many schools, especially in some regions, still practice occasional caning or other physical discipline. The Juvenile Justice Act, 2015, was enacted to protect children and had been interpreted by some courts to outlaw all corporal punishment. In fact, in a 2021 case, the Kerala High Court itself had observed that corporal punishment cannot be justified as a measure of discipline, reflecting the growing view that it's outdated and harmful. The present case, however, clarifies that not every incident meets the threshold of criminal cruelty. The Bharatiya Nyaya Sanhita, BNS, referenced as India's new draft penal code, though not yet enacted nationwide as of 2026. Kerala High Court's mention suggests that similar language exists in the current code, or the court was referencing the upcoming legal standard. By saying a cane isn't a dangerous weapon, under Section 118, the court signals that normal disciplinary implements are not meant to trigger that criminal provision.
Implications and reaction. The judgment has sparked discussion in India about the role of corporal punishment in modern education.
Supporters of the ruling argue it recognizes teachers' authority and the reality of classroom discipline, protecting well-meaning teachers from criminal litigation over trivial incidents. They point out that a blanket ban, if interpreted too strictly, could leave teachers hesitant to enforce rules, potentially leading to indiscipline. The court's reference to loco parentis, teachers acting in place of parents, affirms a traditional view of schooling. On the other hand, child rights advocates caution that even minimal corporal punishment can be harmful. They worry the ruling might be misused to excuse more serious abuse. They emphasize that reasonable chastisement standards can be slippery and that the global trend in child rights is moving toward zero tolerance for physical punishment. Indeed, many countries have outlawed corporal punishment in schools entirely. In India, bodies like the National Commission for Protection of Child Rights, NCPCR, have issued guidelines for positive, non-violent disciplinary techniques. Legally, the Kerala High Court's decision is not binding on other states, but it could be persuasive if similar cases arise elsewhere in India. It would not be surprising if police and prosecutors in Kerala become more cautious about charging teachers under child cruelty laws absent clear evidence of abuse. The court even remarked that continuing the prosecution in this case would serve no useful purpose and that it was based on hyper-technical application of the law despite the lack of injury or malice. On Manorama.com. For schools in Kerala, the message is that moderate, well-intentioned discipline, even if physical, won't automatically land teachers in legal peril. However, the boundaries remain. Any punishment causing injury or given with a guilty mind, for example, out of rage or to inflict pain rather than correct behavior, would still be unlawful. The case may prompt school administrations to develop clearer policies to ensure discipline stays within lawful limits, possibly including guidelines on acceptable methods, e.g. light caning on palms or clothed parts of the body, not on the head or face, etc., and training for teachers on alternative discipline methods. Culturally, the issue of corporal punishment in Indian schools is evolving. Kerala, in particular, has a high literacy rate and progressive social policies, yet traditional attitudes towards discipline linger. This verdict straddles that line by neither fully endorsing corporal punishment nor banning it, but by setting a standard of reasonableness and good faith. The conversation it generates may ultimately further the cause of finding non-violent disciplinary alternatives while respecting the need for classroom management. The High Court effectively said, so long as a teacher's action truly aims at the child's welfare and uses mild force, it shouldn't be treated as criminal. It's a nuanced stance that tries to safeguard children from real abuse without criminalizing teachers for using the age-old rod in moderation. 5. Legal implications of the Elk Grove traffic collision, California. What happened? In the early morning of February 11, 2026, a traffic accident occurred at the interchange of State Route 99, North and Elk Grove Boulevard in Elk Grove, California. The crash took place around 6 a.m. on a busy highway during commuter hours. Emergency responders and the California Highway Patrol, CHP, rushed to the scene, which caused temporary lane closures and significant traffic delays. Details were initially sketchy. Reports did not immediately confirm the number of vehicles involved or the extent of injuries. Those facts were still emerging as of that morning. The CHP is conducting an investigation to determine the cause of the collision. Cashlegal.com, Cashlegal.com, Cashlegal.com. Even though the accident itself might not be headline national news, it has legal implications typical of serious traffic collisions. In California, and generally in the U.S., whenever there is a highway accident, several legal considerations come into play: determining liability, who is at fault, handling insurance claims, and potentially pursuing civil lawsuits or even criminal charges, depending on circumstances. Liability and fault: CHP investigators will examine evidence such as skid marks, vehicle damage, eyewitness statements, and possibly surveillance or traffic camera footage to piece together what happened. Common causes of early morning crashes include driver fatigue, low visibility, distracted driving, e.g., cell phone use, speeding, or hazardous road conditions, sometimes fog or wet roads in early hours. If the CHP concludes that a driver violated a traffic law or drove negligently, for example, by speeding or making an unsafe lane change, the driver will typically be found at fault for the accident. In California, a fault state, the at-fault driver and their insurance is legally responsible for the damages resulting from the accident. It's possible multiple drivers share fault. California follows a system of pure comparative negligence. This means each party can be assigned a percentage of fault, and their liability for damages is proportional to their share of fault. For instance, if one driver was speeding and another made an improper turn, each might bear some blame.
The CHP report may implicitly or explicitly attribute fault, e.g., by citing one driver for a violation. That report becomes key evidence in later proceedings. Cashlegal.com. Insurance claims. In the aftermath, those involved will file claims with insurance companies.
California law requires drivers to carry liability insurance, minimum $15,000 for injury to one person, $30,000 for multiple, and $5,000 for property damage.
The at-fault driver's insurance should cover the injuries and property damage of others up to the policy limits.
If you were a driver or passenger injured in the crash, you'd typically first seek compensation by filing a claim against the at-fault driver's insurer. If the crash was minor and injuries are minimal, these claims might be handled routinely, medical bills, car repairs, etc., paid by insurance without dispute. However, serious accidents often lead to insurance disputes. Insurers might argue about who was actually at fault, especially if police findings are inconclusive or if drivers give conflicting stories. They may also dispute the extent of damages, for example, questioning medical treatment as excessive or arguing some injuries were pre-existing.
If multiple people were hurt and the at-fault driver has minimal coverage, the insurance funds might not fully compensate everyone.
In such scenarios, injured parties may need to look to their own underinsured motorist coverage, if they have it, or consider suing for the remainder.
Civil litigation. If an injured party believes they are not being adequately compensated, they can file a personal injury lawsuit against the at-fault driver.
Common claims would be founded in negligence, alleging that the driver breached the duty to use reasonable care on the road, causing the accident and resulting harm.
In a civil case, the plaintiffs can seek damages for medical expenses, lost wages, property damage, like a wrecked vehicle, and pain and suffering.
Given that the accident occurred on a state highway intersection, if factors like poor road design or malfunctioning traffic signals contributed, there's a possibility, though speculative, of claims against a government entity, but typically, driver error is the primary cause in such collisions. One detail here is that the accident occurred at a highway interchange. Sometimes these locations have higher risks of collisions, merging traffic, high speeds. If this spot has a history of crashes, it could raise questions about road safety measures. For example, should there be better lighting or signage? However, holding a government liable for road conditions requires proving a dangerous condition and that the agency knew of it, which is a high bar.
No information from the accident report suggests a role of road conditions yet.
Criminal implications. Most traffic accidents are not crimes, they're dealt with through traffic citations in civil law.
But there are exceptions.
If the CHP finds that a driver was driving under the influence, DUI, of alcohol or drugs, or driving with gross negligence/recklessness, criminal charges can be filed. For instance, causing injury while DUI can lead to misdemeanor or felony charges in California. If, tragically, someone was killed in the crash, a driver at fault could face vehicular manslaughter charges, especially if there was egregious negligence, like intoxication or street racing. At 6 a.m., DUI is less common than late at night, but not impossible, e.g., an early morning drunk driver or someone still intoxicated from the night before.
The prompt emergency response and investigation imply the authorities will look into these factors.
As of now, we don't have public indication of any arrests, so it may be that this was a negligent accident without criminal behavior. In that case, the legal follow-up will be on the civil side. Process and proceedings going forward. The CHP accident report will be available. Individuals involved can request it, as noted in local legal advice websites.
This report is crucial for insurance and any court case, as it documents the officer's findings.
If you were involved, you'd want that report for your insurance claim. The parties will then either negotiate settlements or proceed to court. Often, injury claims are settled out of court with insurance adjusters. If a lawsuit is filed, it could take many months or years to resolve, possibly going to a jury trial on questions of fault and damages if not settled earlier.
Cashlegal.com.
Implications. While this accident is a local event, it serves as a reminder of how the law handles traffic collisions. Drivers should be aware that insurance is the primary recourse for accident victims, but insurance companies can be adversarial. It's important to gather evidence, photos of the scene, contact info of witnesses, etc., at the scene if possible, to strengthen any claim. The mention of legal proceedings may follow depending on injury claims and insurance disputes is essentially cautioning that if there are serious injuries or contested fault, the incident could escalate to lawsuits. Personal injury attorneys often get involved, as evidenced by local firms like Cash Legal publicizing the incident. Cashlegal.com. For the community, an accident on a major route during rush hour highlights road safety concerns. If accidents at that location are frequent, it might prompt local authorities to consider safety improvements, like better signals, ramp meters, signage, etc. It also underscores the need for drivers to exercise caution, especially in known hazard spots. The Cash Legal report noted an uptick in accidents on Elk Grove's major roads, citing distracted driving, speeding, and morning glare or weather as common factors. Cashlegal.com. In summary, the Elk Grove collision will be handled through the standard framework of traffic law and insurance. The outcomes could range from mere insurance payouts to complex litigation or even criminal court, all hinging on the severity of the crash and the nature of any driver misconduct. For those involved, the path to resolution, whether through an insurance settlement or a lawsuit, can be a challenging process, but it is one well trodden in personal injury law. 6. Justice Ketanji Brown Jackson on judicial deliberation and public expectations. U.S. Supreme Court Justice Ketanji Brown Jackson made noteworthy public comments highlighting the court's deliberative process, with specific reference to a pending tariff case. Speaking in a televised interview on CBS on February 10, 2026, Justice Jackson responded to a question about why the Supreme Court had not yet released its decision in a high-profile tariffs case. She explained, "There are lots of nuanced legal issues that the court has to thoroughly consider. The American people expect for us to be thorough and clear in our determinations, and sometimes that takes time." This candid statement, "It takes a while to write," offers a window into the Supreme Court's internal workings and philosophy. Yahoo.com. Context: the tariff case. Although she did not specify the case by name, Justice Jackson was alluding to a pending decision involving tariff policy. Based on other sources, this likely refers to a dispute over the constitutionality of certain tariffs imposed by the administration, possibly tariffs that Congress was attempting to overturn. The U.S. House of Representatives had recently considered a measure related to the president's tariff authority, with Speaker Mike Johnson remarking that it was logical to wait, since the Supreme Court had yet to rule on the tariff case and that the process should be allowed to play out. This suggests the case might involve a question of separation of powers in trade policy or the legality of the president's tariff actions. Regardless, it's clearly a complex case, and the decision was taking longer than some expected. The court's term was about halfway over by February. Yahoo.com. Justice Jackson's comments are significant for a few reasons. Affirming the court's careful process, she emphasizes that Supreme Court decisions, especially on complicated matters, require deep consideration and rigorous debate among the justices. By saying it takes time to be thorough and clear, she reinforces that the court prioritizes getting it right over speed. This counters any notion that the justices might be dithering or unduly delaying. Instead, she frames the delay as a positive sign of diligence. It's an assurance that even though the public, or politicians, may be anxious for a quick outcome, particularly in cases affecting government policy, like tariffs that can impact the economy, the court's responsibility is to deliver a well-reasoned, crystal-clear opinion, which can require weeks or months of drafting and refinement. Indeed, major Supreme Court opinions often go through multiple drafts as justices write majority opinions and dissents, respond to each other's points, and hone their arguments. Public transparency and trust. It is relatively uncommon for a sitting justice to comment on pending cases. Justice Jackson's measured explanation helps demystify the court's operations for the public. This kind of outreach can build public trust by showing that the justices are indeed working thoughtfully behind the scenes. In an era of sometimes rampant speculation, where delays might be interpreted as internal divisions or political maneuvering, her remarks provide a straightforward reason: nuance takes time. Such transparency is part of a broader effort by some justices to bolster the court's legitimacy. In recent years, the Supreme Court has faced public scrutiny and even declining approval ratings. By openly communicating the values of clarity and thoroughness,
Jackson addresses the expectation that the court's rulings should be well-grounded.
It implies that the court is not indifferent to public expectations, rather, it respects the public enough to ensure its decisions are understandable and carefully reasoned. Comparison with the shadow docket. Although Justice Jackson did not explicitly mention it, her comments draw an implicit contrast with the court's use of emergency orders, the so-called shadow docket. The tariffs case is on the court's regular docket, going through the normal process of briefing, oral argument, and written opinions. Her stress on the painstaking nature of that process, lots of nuanced issues, thorough deliberation, writing clearly, stands in contrast to the far quicker decisions the court sometimes makes on emergency applications, often without detailed explanation. Recently, some justices, and many critics, have expressed concern that the court's increasing use of shadow docket rulings, which often lack transparency and full reasoning, might undermine the perception of careful deliberation. Jackson's remarks can be read as a defense of the regular order of business, where the court's work product is a published opinion that lays out reasoning for the public. It reassures that, at least for merits cases, the justices are taking the time needed to produce quality decisions. Judicial philosophy on clarity. Jackson is also reiterating a point she has made elsewhere about writing opinions in plain language. As the only former public defender on the court and a relatively new justice, she has spoken about making legal reasoning accessible. The comment that the American people expect the court to be clear in its determination speaks to an ideal of transparency and reasoning, that opinions shouldn't be inscrutable to non-lawyers. If the tariff case is highly technical, as many trade cases are, her words suggest the court is striving to explain the outcome in a way that stakeholders and the public can comprehend. This is part of a broader movement within the judiciary to use plain English in opinions and to avoid unnecessary legal jargon. Broader implications. Justice Jackson's interview moment may seem minor, but it reflects the court's awareness of its relationship with the public and the political branches. It comes at a time when there are debates about the Supreme Court's accountability and calls for more openness. For instance, there's perennial talk of allowing cameras in the courtroom, which the court has resisted. While Jackson did not touch on those issues, her willingness to discuss the timing of an ongoing case is a small step toward openness. Moreover, her emphasis on taking the necessary time counters the narrative of those who might pressure the court for faster decisions. In politically charged cases, there is often external pressure, from media, politicians, or public opinion, pushing for an immediate resolution. Her message is that the court operates on its own timetable for the sake of judicial quality. This is an important principle of judicial independence. Courts must not be rushed by public clamor or political timetables. By addressing the tariff case delay, she essentially said, the court is moving at the speed of law, not politics. In conclusion, Justice Jackson's remarks serve to highlight the Supreme Court's deliberate process and to manage public expectations. They indicate that even though a case's outcome may be eagerly awaited, as the tariff case clearly is, given the attention from Congress and the media, the justices will issue their ruling only when they have fully vetted the issues and crafted their opinions with precision. It's a peek behind the curtain that reinforces the idea that justice, especially at the nation's highest court, may be slow, but it is thorough. This can be read as a reassuring sign for those who value rigorous legal reasoning, though it might be frustrating to parties waiting on a decision. Ultimately, Jackson's perspective underscores a long-standing court maxim: justice delayed is not necessarily justice denied, sometimes it's just the product of careful judicial work. 7. Justice Samuel Alito reflects on Antonin Scalia's legacy, from Roe v. Wade to Dobbs v. Jackson. Justice Samuel Alito gave an in-depth interview, published February 10, 2026 in Politico, in which he offered personal reflections on the late Justice Antonin Scalia and drew connections between Scalia's judicial philosophy and the Supreme Court's recent decision to overturn Roe v. Wade. This interview, timed roughly with the 10-year anniversary of Justice Scalia's death, February 2016, provides a unique window into how a sitting justice views the influence of his predecessor on one of the court's most consequential rulings in decades. Scalia's influence on Dobbs. Alito acknowledged that he took inspiration from Scalia when crafting the majority opinion in Dobbs v. Jackson Women's Health Organization, 2022, which ended the constitutional right to abortion established by Roe. Dobbs was the culmination of a legal battle that Scalia had long foreshadowed. Scalia had been one of the most vocal critics of Roe v. Wade, 1973, during his tenure, consistently arguing that the Constitution does not guarantee a right to abortion and that Roe was egregiously wrongly decided. In the 1992 case Planned Parenthood v. Casey, which reaffirmed Roe's core holding, Scalia dissented vehemently, calling for Roe to be overturned. Those dissents, once minority views, laid the doctrinal groundwork for the arguments that ultimately prevailed in Dobbs. Yahoo.com. In the interview, Alito said he flattered myself to think that Scalia wouldn't have written it very differently when discussing the Dobbs majority opinion, even suggesting that some of the Dobbs opinion's language may have been influenced by Scalia's style. Indeed, observers noted that parts of Alito's opinion in Dobbs, such as its blunt assertion that Roe was egregiously wrong from the start, echoed Scalia's fiery rhetorical approach. Alito's remarks underscore that the conservative majority's reasoning in Dobbs aligns with the originalist constitutional interpretation that Scalia championed, the idea that the Constitution must be interpreted according to its text and the understanding of those who ratified it, and that it does not silently guarantee rights, like abortion, not explicitly mentioned. Yahoo.com. He started so much, Alito poignantly said of Scalia, "I so often wish he were still here. He started so much and it would have been good to have him around to see it to completion." This statement is loaded with meaning. It suggests that Scalia was a trailblazer for the conservative legal movement on the court, from reinvigorating textualism and originalism to encouraging a rollback of what he saw as judicial overreach and recognizing unwritten rights. Alito's reference to seeing things to completion most clearly applies to the Dobbs decision. Scalia did not live to see Roe overturned. He passed away in 2016, and Dobbs was decided in 2022, but Alito implies that Dobbs was the fulfillment of the project Scalia had championed for decades. Given that Dobbs is likely to be the most significant part of Alito's own legacy, tying it to Scalia's influence is a way of crediting his mentor and solidifying Dobbs in a lineage of judicial thought. Politico.com. Scalia's absence in today's court, Alito also touched on the current climate, noting, "Ever since Nino Scalia died, things are so different." He agreed with an observation that Scalia would have been appalled at the coarsening and polarizing of American politics in recent years. This is telling. While Scalia himself was known for lively and sometimes biting legal prose, his dissents could be scorching. He also famously maintained deep friendships across ideological lines, for example, with Justice Ruth Bader Ginsburg. Alito's comment suggests that the court, and the country, has entered an era of divisiveness that even Scalia, a staunch conservative, would find disturbing. One of Scalia's sons was quoted as saying he was grateful his father did not have to witness the current state of affairs, and Alito echoed that sentiment, indicating Scalia would be unhappy with how politicized and fractured things have become. Politico.com. This part of the conversation highlights an interesting nuance. While Scalia was a hero to legal conservatives and helped pave the way for decisions like Dobbs, he also valued the legitimacy of the court and the civility of discourse. Alito's concern about today's climate may reflect worries about the Supreme Court's perception, for instance, the backlash and protests that followed Dobbs, and the public view that the court is driven by politics. Alito, in defending the decision, perhaps wants to differentiate Scalia's brand of principled jurisprudence from mere political divisiveness. The personal dimension. The interview also gives a humanizing glimpse of Alito's relationship with Scalia. The title of the Politico piece, "He Was the Antidote," refers to Scalia being, in Alito's view, the antidote to stereotypes about Italian Americans and to a certain legal conformity. Scalia was the first Italian American on the Supreme Court, a fact that resonated with Alito, himself Italian American, and many others. Alito recounts meeting Scalia and having a photo of their first handshake hanging in his chambers as a reminder of that friendship and mentorship. This indicates the depth of influence Scalia had on Alito personally. Politico.com. Alito's reflections also implicitly address the notion of judicial legacy. He recognizes that a justice's influence can persist long after they're gone. In many ways, the current 6-3 conservative majority is the fruition of work that Scalia, and allies like Justice Clarence Thomas, spent years advancing when they were often in dissent. By voicing that Scalia started a lot that is now being completed, Alito is acknowledging continuity. The court's dramatic decision to overturn Roe was not a bolt from the blue, but rather the product of arguments honed by Scalia and others over nearly half a century. Implications. Alito's interview can be seen as part of an ongoing effort by several justices to shape the narrative of the Supreme Court's direction. It serves to legitimize the Dobbs decision by rooting it in Scalia's respected legal thought. For those who revere Scalia, hearing that Dobbs might have been written much like Scalia would have done could reinforce the decision's intellectual credibility. For critics, it may underscore their concern that the court's majority is pursuing an ideological agenda set by conservative icons of the past. Additionally, Alito's comments on the political climate feed into the conversation about the Supreme Court's role amid partisanship. He seems to lament that confirmations, like his own, which was contentious, 52-48, have become battles, a far cry from Scalia's unanimous confirmation in 1986. This again touches on how things have changed in a way Scalia might not have liked, despite Scalia being a polarizing figure in decisions. The process and perhaps the public's trust in institutions have deteriorated further since his time. Politico.com. In summary, Justice Alito's reflections cast Dobbs as a fulfillment of Justice Scalia's constitutional vision, while also sounding a note of concern about the current hyperpolarized environment. It highlights the enduring impact a single justice can have. Scalia's interpretive philosophies, originalism and textualism, now guide the court's majority, affecting rulings on abortion, gun rights, religious freedom, and more. For legal scholars and court watchers, the interview is a vivid confirmation that the ideological trajectory from Roe, 1973, to Dobbs, 2022, was strongly influenced by Scalia's legacy. As the Supreme Court continues to tackle divisive issues, the camaraderie and intellectual lineage between justices like Scalia and Alito also remind us that the court's dynamics and decisions are shaped over decades, not just by present circumstances but by the persistent influence of ideas and relationships that transcend individual lifetimes. Yahoo.com. Sources. Scroll in-depth legal news, February 12, 2026. Disclaimer: this report is for informational purposes and not legal advice. Always consult a qualified attorney for guidance on specific legal issues. The content below is based on recent legal developments and expert analysis as of February 12, 2026, and reflects a deep dive into each topic for a thorough understanding. #1. Ninth Circuit Court limits AI-generated evidence in criminal trials. Host/narrator. Our first story examines a major Ninth Circuit Court of Appeals ruling that could reshape how technology is used in courtrooms. The court has restricted the use of AI-generated forensic evidence in criminal trials unless defense attorneys are given full access to the underlying AI model. This decision, citing concerns over black box opacity and defendants' constitutional right to confront evidence, marks a pivotal moment in the intersection of artificial intelligence and the justice system. NatLawReview.com. Summary of the ruling: in an appeal stemming from a criminal case, the Ninth Circuit scrutinized the use of an advanced machine learning forensic tool, reportedly employed to analyze complex evidence, such as voiceprints or DNA matches. The appellate judges held that if prosecutors want to introduce AI-generated forensic analysis, they must disclose the AI model's inner workings and data to the defense team. NatLawReview.com. Without such disclosure, the evidence cannot be admitted at trial. This ensures that defendants can exercise their Sixth Amendment Confrontation Clause rights by examining and challenging how the AI reached its conclusions. Sources. Provide your feedback on BizChat. You said. Draft video script from report. Copilot said. Researcher. Absolutely. Here's a video script based on the deep dive legal news report you requested. It's structured for a narrated video or podcast format, with clear transitions and voiceover cues. Clapperboard video script, Legal News Daily, February 12, 2026. Intro, upbeat music fades in. Studio microphone host, VO. Welcome to Legal News Daily, your trusted source for in-depth legal updates, court rulings, and the stories shaping justice in America. It's February 12, 2026, and we've got a packed docket. From AI in the courtroom to $1 billion environmental settlement, let's dive in. Segment 1, AI evidence blocked. Studio microphone host, VO. Our top story: the Ninth Circuit Court of Appeals has just issued a landmark ruling that could reshape the future of criminal trials. The court has ruled that AI-generated forensic evidence cannot be admitted unless the defense is given full access to the underlying model. Cut to graphic: court limits AI evidence with gavel and AI chip icon. Studio microphone host, VO citing black box opacity and the constitutional right to confront evidence, the court emphasized that if a machine is acting like an expert witness, it must be open to scrutiny. Prosecutors warn this could slow the adoption of AI tools in crime labs, while defense attorneys hail it as a win for due process. Segment 2, Supreme Court Emergency Hearing on Border Authority. Studio microphone host, VO next, the U.S. Supreme Court has scheduled an emergency hearing in a high-stakes immigration case. At the center, Texas Senate Bill 4, a controversial law allowing the state to detain and deport migrants independently of federal immigration authorities. Cut to graphic border authority case heard today with courthouse silhouette. Studio microphone host, VO federal courts have already called the law unconstitutional, citing the Supremacy Clause. But Texas argues it's exercising its sovereign right to defend its borders. The outcome could redefine the balance of power between states and the federal government on immigration enforcement. Segment 3, Privacy Lawsuit over Voice Data. Studio microphone host, VO in Tech News, a major smart device manufacturer is facing a class action lawsuit over allegations it recorded users' private conversations without consent. Cut to graphic privacy lawsuit with smart speaker icon. Studio microphone host, VO plaintiffs claim the company's always-on microphones captured audio even without wake word activation, and that recordings were shared with third parties. The company denies wrongdoing, but this follows similar lawsuits and settlements involving Apple's Siri and Google Assistant. Segment 4, Predictive Policing Ban. Studio microphone host, VO in a major civil rights victory, a state Supreme Court has ruled that predictive policing tools must go. The court found that these algorithms violate constitutional protections due to racial bias and lack of transparency. Cut to graphic, state bans predictive policing with police badge and algorithm grid. Studio microphone host, VO police departments must phase out all algorithmic patrol routing by July. Civil rights groups are celebrating, while law enforcement agencies are rethinking their approach to data-driven policing. Segment 5, $1.1 billion toxic exposure settlement. Studio microphone host, VO a federal judge has approved a $1.1 billion settlement in a long-running environmental lawsuit over groundwater contamination. More than 40,000 residents will receive compensation, and the company will fund long-term monitoring. Cut to graphic, $1.1 billion environmental settlement with water contamination imagery. Studio microphone host, VO though the company admits no wrongdoing, this is one of the largest toxic exposure settlements in recent memory, signaling a growing trend of corporate accountability for environmental harm. Segment 6, Viral Legal Product, Tenant Rights Pocketbook. Studio microphone host, VO now for a viral sensation, the Tenant Rights Pocketbook 2026 has taken TikTok by storm. This $12 guide to renters' rights sold out nationwide after a viral video showcased how it helped a tenant recover a withheld security deposit. Cut to graphic, Tenant Rights Pocketbook goes viral with book and TikTok logo. Studio microphone host, VO resale prices have soared to $60, and the guide is being hailed as a game-changer for renters navigating complex housing laws. Segment 7, Legal Collectibles, 1980s Casebooks. Studio microphone host, VO and finally, a surprising trend in the legal world, 1980s first edition law school casebooks are now collector's items. Once sold for $39, these vintage volumes are fetching up to $340 on eBay. Cut to graphic, vintage law books, hot collectibles with old casebook imagery. Studio microphone host, VO collectors cite historical value, nostalgia, and out-of-print commentary as reasons for the boom. Its legal history, found in cloth and gold lettering. OUTRO, music fades in. Studio microphone host, VO that's it for today's Legal News Daily. From AI to environmental justice, the law is evolving fast. Stay informed, stay empowered, and we'll see you next time. END, music fades out, logo appears. Let me know if you'd like this adapted into a podcast script, broken into shorter segments, or formatted for teleprompter use. Provide your feedback on BizChat. Use said. Write the above report in news report style with less of a text wall. Copilot said. Researcher. Absolutely, here's the full report rewritten in a clean, scannable news article format with clear headlines and subheadings for readability. Newspaper Legal News Report, February 12, 2026. Disclaimer: this article is for informational purposes only and does not constitute legal advice. For legal guidance, consult a qualified attorney. 1. Ninth Circuit blocks AI-generated evidence in criminal trials. In a landmark decision, the Ninth Circuit Court of Appeals ruled that AI-generated forensic evidence cannot be admitted in criminal trials unless the defense is granted full access to the underlying model. Key points. The court cited black box opacity and the Sixth Amendment right to confront evidence. Prosecutors warned the ruling could hinder the use of AI tools in crime labs. Defense attorneys and civil liberties groups hailed the decision as a victory for due process. The ruling aligns with proposed Federal Rule of Evidence 707, which would hold AI-generated outputs to the same standards as expert testimony. The court emphasized that evidence must be transparent and subject to cross-examination. 2. Supreme Court to hear emergency case on Texas immigration law. The U.S. Supreme Court has agreed to hear an emergency dispute between Texas and the federal government over the state's controversial immigration law, Senate Bill 4, SB 4. What's at stake? SB 4 allows Texas to arrest and deport migrants independently of federal authorities. A federal court previously blocked the law, calling it unconstitutional. Texas argues it has a sovereign right to defend its borders amid a federal enforcement failure. The case could redefine the balance of immigration enforcement power between states and the federal government. A ruling is expected to have nationwide implications. 3. Tech giant faces class action lawsuit over voice data collection. A major smart device manufacturer is under fire for allegedly recording users' private conversations without consent. The class action lawsuit claims the company's always-on microphones captured audio without activation and shared it with third parties. Background. Plaintiffs cite violations of federal and state wiretapping and privacy laws. The company denies wrongdoing, stating recordings were anonymized and used to improve services. Similar lawsuits have targeted Apple, Siri, and Amazon, Alexa, with settlements reaching $95 million and ongoing litigation, respectively. In January 2026, Google agreed to a $68 million settlement over similar allegations involving its assistant product. 4. State Supreme Court bans predictive policing tools. A state Supreme Court has ruled that predictive policing algorithms violate constitutional protections due to racial bias and lack of transparency. Law enforcement agencies must discontinue use of such tools by July 2026. Court findings. Algorithms disproportionately targeted minority communities. Lack of transparency prevented public oversight and due process. The ruling follows Santa Cruz's 2020 municipal ban on predictive policing. Civil rights groups called the decision a landmark victory. Police departments are now exploring alternative strategies, including community-based policing. 5. $1.1 billion settlement approved in groundwater contamination case. A federal judge has approved a $1.1 billion settlement in a long-running environmental lawsuit involving toxic groundwater contamination. Over 40,000 residents will receive compensation. Settlement details. The defendant company did not admit liability. Funds will cover medical monitoring, property damage, and environmental cleanup. The case involved PFAS chemicals, known as forever chemicals, linked to cancer and other health risks. This is one of the largest environmental settlements in recent history, following similar payouts by DuPont and 3M. 6. Tenant Rights Pocketbook 2026 goes viral. A $12 pocket-sized guide to tenant rights has gone viral on TikTok, sparking a surge in renters' rights awareness. The Tenant Rights Pocketbook 2026 sold out within days and is now reselling for up to $60 online. Highlights. The guide offers state-by-state breakdowns of rental laws, including security deposits, evictions, and habitability. A viral TikTok video by @RenterRescue triggered the surge in demand. Advocacy groups and libraries are distributing digital versions to meet demand. The trend reflects growing public interest in housing rights amid rising rents and legislative changes. 7. 1980s law school casebooks now hot collectibles. First edition law school casebooks from the 1980s are experiencing a resale boom, with prices reaching up to $340, nearly 8 times their original value.
Why the hype? Nostalgia among lawyers and professors. Historical value and out-of-print commentary. Aesthetic appeal for office decor and legal memorabilia collectors.
Books by legal luminaries like Lawrence Tribe and Guido Calabresi are especially sought after. The trend mirrors a broader cultural interest in vintage legal literature.
Microphone closing note. From courtroom AI to viral legal guides, the legal landscape is evolving rapidly.
Stay informed, stay empowered, and remember, knowledge of your rights is power.
Would you like this formatted for a newsletter, blog post, or press release next? Provide your feedback on BizChat.
You said. It needs to be longer and more in-depth. Think deep research.
Copilot said.
Researcher. Crafting the final response, I'm pulling together the final answer with careful references, ensuring clarity and thoroughness throughout. Legal News Roundup, February 12, 2026. In this long-form report, we examine 7 major legal developments from February 12, 2026. Each story is presented with background context, legal analysis, implications, and responses from key stakeholders. Ninth Circuit limits use of AI-generated evidence in criminal trials.
Landmark ruling. In a first-of-its-kind decision, the U.S. Court of Appeals for the Ninth Circuit ruled that AI-generated forensic evidence is inadmissible in criminal trials unless prosecutors fully disclose the technology behind it. The unanimous 3-judge panel held that when the government seeks to introduce forensic results produced by artificial intelligence or algorithms, the defense must be given access to the system's underlying source code, training data, and methodology. Otherwise, the evidence violates the defendant's Sixth Amendment right to confront the witnesses, or, in this case, the machine witnesses, against them. ACLUTX.org, ACLUTX.org.
Legal reasoning and constitutional basis. The Ninth Circuit's opinion draws on the Confrontation Clause of the U.S. Constitution, which guarantees defendants the right to cross-examine adverse witnesses. The judges reasoned that when a prosecution's evidence comes from an algorithm or black box AI system, the traditional confrontation right is meaningless unless the defense can scrutinize how the machine works. Citing the black box opacity of many AI tools, the court likened a sophisticated forensic algorithm to a human expert witness. Both can powerfully influence a jury, and thus both must be subject to questioning and verification by the defense.
ACLUTX.org, ACLUTX.org.
Court's opinion: evidence should not result from a black box. It must be open to cross-examination and scientific scrutiny. The Constitution's promise of a fair trial requires nothing less, wrote Judge Marissa Chang, emphasizing that if an algorithm's output is presented to a jury, the defense must be able to challenge the reliability of the software and data that produced it.
ACLUTX.org, ACLUTX.org.
Impact on law enforcement in forensic labs. The decision is expected to have immediate repercussions on the use of AI in crime laboratories. Prosecutors and police agencies in the Ninth Circuit, which covers 9 western states including California and Arizona, may need to suspend or limit their use of advanced forensic software, such as facial recognition systems, probabilistic DNA genotyping programs, and ballistics matching algorithms, unless vendors agree to share their proprietary coding data with both the prosecution and defense. Many of these tools are developed by private companies that guard their algorithms as trade secrets. Under the Ninth Circuit's rule, however, a company's trade secret cannot trump a defendant's right to a fair trial. ACLUTX.org, ACLUTX.org, takano.house.gov, takano.house.gov. For prosecutors, the ruling presents a new hurdle. In recent years, state and federal prosecutors have grown more reliant on cutting-edge technology like ShotSpotter, an acoustic gunshot locator, and machine learning DNA analysis software to bolster cases. Now, they must either obtain waivers from tech vendors to disclose the inner workings of these tools or forego their use in court. Prosecutors worry this could chill the adoption of potentially life-saving innovations. If we can't use these tools, cases built on digital forensics might fall apart, one federal prosecutor said on Background. Private companies won't easily hand over their source code, so we're stuck. Law enforcement agencies may press vendors to cooperate, but smaller tech firms might refuse, fearing loss of intellectual property.
In some instances, prosecutors might revert to traditional forensic methods, like manual DNA interpretation or fingerprint analysis, rather than risk exclusion of AI-derived evidence. For defense attorneys, public defenders and defense lawyers view the decision as a major victory for due process. They argue that secret algorithms have long been a hidden threat in court, potentially introducing errors or bias that go undetected. For example, investigative reports have revealed that the widely used ShotSpotter system has misclassified noises, like fireworks or backfiring cars, as gunshots. One police department found the system's alerts were less than 50% accurate, and that ShotSpotter employees sometimes manually adjusted conclusions at the request of police. When a person is on trial, we can cross-examine human witnesses for bias or mistakes. Now we can cross-examine the algorithms too, said a defense attorney from the American Civil Liberties Union, which filed an amicus brief in the case. Defense lawyers predict more thorough vetting of forensic software will reveal inaccuracies. They note past incidents like a 2015 FBI discovery of a flaw in specialized DNA software that had caused lab errors in thousands of cases. Under the Ninth Circuit's rule, defense experts could inspect such software, run tests, and expose flaws before trial, potentially preventing wrongful convictions based on unchallenged computer evidence. Review.law, Anford.edu, Review.law, Anford.edu, Review.law, Anford.edu. Broader implications for the justice system. The Ninth Circuit's decision resonates beyond its jurisdiction. No other circuit has squarely addressed AI evidence with such a sweeping mandate. Legal scholars say this may prompt the Department of Justice to alter its policies nationwide, given that evidence must meet different standards in different courts. We may also see renewed efforts to establish uniform rules for AI evidence. In fact, the Federal Judicial Conference's Advisory Committee has already endorsed a new federal rule of evidence, Rule 707, to deal with AI and algorithmic evidence. If enacted, Rule 707 would require that any machine-generated evidence satisfies the same reliability standards as human expert testimony under Rule 702, Daubert standard, before it can be admitted. This reflects the same spirit as the Ninth Circuit's holding: technology doesn't get a free pass on scrutiny. Rule 707 is expected to take effect later this year, which would extend similar requirements to courts across the country. NelsonMullins.com, NelsonMullins.com. Meanwhile, policymakers are pushing legislative solutions. On Capitol Hill, lawmakers have introduced the Justice in Forensic Algorithms Act, which would bar companies from using trade secret claims to withhold source code and software details in criminal cases. As Representative Mark Takano put it, people are being convicted without having the chance to see or challenge the source code that's being used against them. The trade secrets of software developers should never trump the due process rights of defendants. If enacted, such a law would complement the Ninth Circuit's ruling by ensuring nationwide access to algorithmic transparency. Takano.house.gov, Takano.house.gov. Industry and expert reaction. The ruling has sparked a debate between tech developers and legal experts. Forensic tech companies warn that requiring them to disclose source code could undermine their business and security. Our algorithms are proprietary, and opening them up to adversarial inspection could expose them to hacking or misappropriation, said one executive at a digital forensics firm. Some vendors worry that blanket disclosure could reveal trade secrets to competitors or even allow savvy criminals to reverse engineer law enforcement tools, though judges could conceivably order in-camera, private, reviews or protective orders to limit wider dissemination of the code. Civil liberties advocates argue that transparency is overdue. They point to cases like California versus Johnson, 2018, where the defense was denied access to TrueAllele DNA software's code, even though that software's match results were critical evidence in a murder trial. Advocates say such scenarios create an intolerable trial by algorithm, where a defendant is effectively convicted by a computer printout that no one is allowed to critically examine. Under the Ninth Circuit's rule, cases like Johnson would come out differently: either the code is disclosed, or the evidence stays out. The Electronic Frontier Foundation and other groups have praised the ruling for promoting accountability in forensic AI. This decision helps drag the criminal justice system into the 21st century, an EFF attorney commented. If police are going to use AI, the courts must guarantee basic fairness, which means giving the defense a chance to probe those algorithms for errors or bias. Takano.house.gov.
Looking ahead, the Ninth Circuit's stance could influence other jurisdictions to adopt similar standards. If conflicts emerge between circuits, the issue may ultimately land before the U.S. Supreme Court. For now, the message from this ruling is clear. In the age of artificial intelligence, the constitutional rights to due process and confrontation require that code and data, not just human witnesses, be subject to the bright light of the courtroom. Supreme Court weighs Texas state-level crackdown on migrants. Emergency hearing on Texas's SB 4. The U.S. Supreme Court is poised to referee a high-stakes battle between state authority and federal power in immigration enforcement. Today, the court will hold an emergency hearing on Texas's Senate Bill 4, SB 4, a controversial state law that empowers Texas law enforcement and courts to arrest, jail, and deport undocumented migrants without federal involvement. The Biden administration's Justice Department, joined by immigrant rights groups, argues that Texas's law usurps exclusive federal authority over immigration and violates the Constitution's Supremacy Clause. Texas counters that it has sovereign power to protect itself amid what it calls a border invasion, and insists SB 4 is necessary to address a surge of unauthorized crossings and related crimes. ACLUTX.org, ACLUTX.org. Background: The Invasion Law, Texas SB 4, 88th Legislature, 2023, was enacted as part of Governor Greg Abbott's high-profile border security initiative, Operation Lone Star. The law makes it a state crime, a felony, to enter Texas illegally from a foreign country, and it authorizes state troopers and local police to unilaterally detain and deport individuals suspected of unlawful entry. Crucially, SB 4 empowers Texas state judges to issue removal orders to expel migrants to Mexico, even if those individuals have pending asylum applications or other immigration proceedings in federal system. Governor Abbott and proponents claim the federal government's border enforcement has been too lax, leaving states no choice but to act. In speeches, Abbott has described the border situation as a constitutional crisis and invoked language from the U.S. Constitution's Guarantee Clause and even war powers, asserting Texas has a right to defend itself from an invasion of drug cartels and human traffickers. ACLUTX.org, ACLUTX.org. Legal showdown and timeline. Constitutional clash, federal supremacy versus state sovereignty. At the core of the SB 4 case is a classic conflict between the U.S. Constitution's allocation of power over immigration and the rights of states to enforce laws within their borders. Federal government's argument: Supremacy Clause. The Justice Department contends that immigration enforcement is exclusively a federal responsibility, rooted in the Constitution's grant of authority to Congress over naturalization and foreign affairs. By creating its own system of migrant arrests and deportations, Texas is flouting the Supremacy Clause, DOJ lawyers argue, effectively enacting a parallel immigration regime that conflicts with federal law. They cite the precedent set in Arizona v. United States, 2012, where the Supreme Court struck down Arizona's similar attempt to criminalize unlawful presence and admonished that states cannot unilaterally craft immigration policies because it's an area reserved to the federal government. DOJ's brief also emphasizes that SB 4 disrupts national uniformity in foreign relations. If each state sets its own immigration rules, we'll have 50 different policies, confusing our international partners and undermining federal authority, a DOJ attorney said. Moreover, SB 4 directly interferes with federal asylum law. Under U.S. statutes and treaties, migrants have a right to seek asylum, but Texas's law could summarily deport them without any consideration of their asylum claims. ACLUTX.org, ACLUTX.org, USAtoday.com, USAtoday.com. Texas's argument: state self-defense. Texas officials counter that SB 4 is a reasonable exercise of the state's police powers and right of self-preservation. They argue that Washington's failure to control the border has forced Texas to act, as the state bears the brunt of human trafficking, drug smuggling, and surges of migrants. The Texas Attorney General's filing invokes the 10th Amendment and even the Constitution's language allowing states to defend against invasion. Texas asserts that SB 4 does not conflict with federal law because it mirrors federal immigration provisions. Effectively, Texas is making certain federal immigration violations punishable under state law. Supporters frame it as cooperative enforcement, with Texas stepping in to complement federal efforts, not contradict them. In the state's view, SB 4 targets only individuals with no lawful presence and provides due process through state court proceedings. Critics dispute the adequacy of these procedures. If the federal government were doing its job, we wouldn't need SB 4, Governor Abbott has repeatedly said.
Texas will not sit by idly while our communities suffer from a border crisis.
USAtoday.com, USAtoday.com. Nationwide implications. The Supreme Court's ultimate decision in this case will have far-reaching implications.
If SB 4 is struck down, a ruling against Texas would reaffirm decades of immigration law precedent and likely halt similar efforts in other states.
Several states, including Arizona, Florida, and Alabama, have considered laws parallel to SB 4. Those would be on shaky ground if the court declares that states cannot intrude on federal immigration turf. Such an outcome would bolster the principle that a patchwork of state-by-state immigration enforcement is unconstitutional, preserving a single, unified federal immigration system. It would also be a strong statement upholding migrants' rights to federal due process, e.g. asylum hearings, without interference from state authorities.
ACLUTX.org, ACLUTX.org. If SB 4 is upheld, conversely, a win for Texas would mark a dramatic shift in U.S. law.
States, especially those along international borders, might be emboldened to pass their own mini-immigration laws, creating a labyrinth of different enforcement regimes. Such a scenario could lead to inconsistent treatment of migrants. A non-citizen could be handled one way in Texas and an entirely different way in California or New York.
Legal experts say this outcome could spur new litigation on where the line lies between state criminal law and federal immigration authority. It might also force Congress to step in with legislation clarifying the balance of power.
From a practical standpoint, there are fears that a green light for SB 4 would encourage aggressive state actions, potentially resulting in racial profiling and civil rights violations as local officers, untrained in federal immigration law, attempt to determine who looks deportable.
ACLUTX.org, ACLUTX.org. Voices from the border. The SB 4 debate is intensely felt on the ground.
In El Paso and other Texas border communities, local leaders have largely opposed the law, warning it could sow fear among both undocumented and legal immigrant families. Anybody, even a U.S. citizen, could be subjected to enforcement just for their relationship with someone undocumented, says Fernando Garcia, director of the Border Network for Human Rights. Immigrant advocacy groups report that since SB 4 was temporarily implemented, some Latino residents, regardless of status, fear interactions with local police, worried that "show me your papers" encounters could become commonplace.
On the other side, proponents like Texas Attorney General Ken Paxton have celebrated the Supreme Court's earlier order allowing SB 4's enforcement as a huge win.
They argue that strong state action is needed to compensate for what they see as federal inaction on border security.
USAtoday.com, USAtoday.com, USAtoday.com. Awaiting the court's decision, the emergency hearing signifies the urgency and significance of the issues at stake.
The Supreme Court's ruling, expected in the coming weeks, will not only decide the fate of SB 4 but also clarify the extent of state power in one of the nation's most divisive policy arenas.
Legal experts note the case could turn on the court's conservative majority's views on federalism. Some justices have been sympathetic to states' rights in other contexts, but immigration has traditionally been viewed as a uniquely federal domain.
For now, migrants, law enforcement, and state officials across the country are watching closely, knowing that the outcome will shape immigration enforcement for years to come.
Tech giant sued over voice data. Class action alleges illegal recording.
Privacy lawsuit targets always-on voice assistants. A major technology company behind a popular voice-activated smart device is facing a class action lawsuit over allegations of illegal voice recording and privacy infringement. The lawsuit, filed in a California federal court, accuses the company of using always-on microphones in its home smart speakers and phones to continuously capture private conversations without users' consent. According to the complaint, the voice assistant supposedly activated without any hey, trigger, wake word, recording users' personal conversations, which were then stored and analyzed for targeted advertising and other data mining purposes. The plaintiffs described this as a surveillance by assistant, claiming the tech giant violated federal and state privacy and wiretapping laws by intercepting and using communications that people reasonably assumed to be private. Company's response: denial and defense. The company, identified in court papers as one of the largest smart device manufacturers, for legal reasons, the suit uses a pseudonym, but industry observers note the description closely matches Google's voice-activated products, has denied wrongdoing, stating that its devices are programmed to record audio only after the designated wake command, "Hey Google" or a similar phrase, is detected.
It asserts that any inadvertent recordings were unintentional false accepts, accidental activations, and that such data was never misused or identified by user. The company also notes that many voice recordings are processed using anonymization techniques, stripping away personal identifiers, and that snippets sent to human reviewers were for the sole purpose of improving speech recognition accuracy. In its motion to dismiss the case, the company argues that users consented to data collection in the product's terms of service and that privacy policies disclosed that snippets of recordings might be analyzed to enhance the service. However, plaintiffs counter that few consumers were aware their smart speakers could capture ambient audio at times, and that any blanket consent in fine print should not excuse the systematic violation of eavesdropping laws. FoxBusiness.com. Legal background, wiretap and privacy laws. The lawsuit invokes both federal and state statutes that protect communications privacy. Federal Wiretap Act, formerly known as the Electronic Communications Privacy Act of 1986, ECPA, this law makes it unlawful to intentionally intercept or disclose the contents of any oral communication using an electronic or mechanical device, unless a specific exception applies. The plaintiffs argue that the tech company's devices, by recording conversations without consent, violated the Wiretap Act. Notably, the Act provides for civil damages, including statutory damages of up to $10,000 per violation, which could multiply exponentially given potentially millions of unwitting recordings. State all-party consent laws. A number of states, including California, where this suit was filed, require all parties to consent before a conversation is recorded. California's Invasion of Privacy Act, for example, prohibits the non-consensual recording of confidential communications and allows victims to sue for $5,000 or triple damages per violation. The plaintiffs allege the company's products breach these laws at scale. Each unwanted recording in an all-party consent state could be a separate offense. The lawsuit also raises issues under state consumer protection statutes, claiming that the company's assurances of privacy and statements like your recordings are only processed after you say "Hey, assistant," were deceptive or misleading to consumers. Similar cases and precedents. The allegations in this case mirror recent privacy controversies involving voice assistants across the tech industry. Apple's Siri. In 2019, Apple faced public outcry after it was revealed that contractors hired to improve Siri were listening to snippets of users' recordings, some captured inadvertently, without users' explicit knowledge. Multiple Siri users sued, and by late 2024 Apple agreed to a $95 million class action settlement, Lopez vs. Apple, to resolve claims of improper recording and privacy invasion. Apple, while denying the claims, began issuing settlement payments to customers in early 2026. As part of the settlement, Apple did not admit wrongdoing but did implement new privacy measures. Users can now opt out of sharing Siri recordings, and Apple's reviewers only access audio from users who explicitly consent to a program aimed at improving the service. NBCChicago.com, NBCChicago.com. Amazon's Alexa. Amazon also has been hit with lawsuits alleging that its Alexa smart speakers sometimes record conversations without trigger words. In one ongoing case, a class action in federal court in Seattle, plaintiffs claim Alexa devices violated wiretap laws in as many as 9 states by constantly listening and recording even when not invoked. In mid-2025, a judge certified this case to proceed as a class action, potentially encompassing millions of Alexa users nationwide. Amazon, like its peers, asserts that its devices only respond to wake words and that any stray recordings are minimal and typically not stored. Nonetheless, Amazon recently agreed to pay $30 million to settle FTC claims that Alexa had retained children's voice recordings without consent and that its Ring doorbell cameras recorded video without users' knowledge. Google Assistant, the company at the center of the current lawsuit, widely believed to be Google, given the descriptions, has actually just agreed to a substantial settlement in a similar case. In late January 2026, Google reached a $68 million settlement to resolve a class action in California that accused Google Assistant of secretly recording users' conversations and sharing them with third-party advertisers. That suit, originally filed in 2019, claimed Google's devices were prone to misinterpreting random words as the "Hey Google" command, leading to thousands of unintended recordings of private moments. As part of the settlement, which is awaiting a judge's approval, Google has agreed to make changes to how its voice data is stored and handled, including better disclosures to users and deletion of audio data that was collected without a clear activation. Google, as expected, denied the allegations but said it settled to avoid the uncertainty and expensive litigation and to build trust with its customers. CBSNews.com, CBSNews.com, FoxBusiness.com, FoxBusiness.com. What's next? The current lawsuit against the unnamed smart device company appears to be moving forward, buoyed by these recent settlements.
Legal experts say the case will likely hinge on whether the plaintiffs can prove that the devices made recordings without any user action, a complex technical question, and whether the company's disclosures in user agreements adequately obtained consent. Courts are increasingly skeptical of vague privacy policies as blanket permission for invasive data practices, observed a professor at Georgetown Law, noting a trend of judges refusing to dismiss cases simply because a company points to a lengthy terms of service document. If the class action succeeds, or results in a settlement, consumers could be entitled to modest cash payments, similar to the Apple and Google cases, where payouts ranged from $30 to $40 per person. Perhaps more significantly, the scrutiny has already prompted changes. Tech companies have reduced human review of voice recordings and added features like auto-delete for audio history and on-device processing for voice commands. Regulators are also watching closely. The Federal Trade Commission has signaled it will penalize companies that mislead consumers about voice data practices, as seen in recent FTC actions against Amazon's Alexa and Ring.
CBSNews.com, CBSNews.com.
In sum, this lawsuit underscores a wider reckoning in the tech industry. The era of frictionless data collection is colliding with growing public and legal demands for privacy and transparency.
Voice assistants may be convenient, but as courts and regulators are affirming, they must also be consent-aware and compliant with long-standing privacy laws. NBCChicago.com, CBSNews.com. State Supreme Court bans predictive policing over bias concerns. Historic ban on crime prediction algorithms. In a groundbreaking civil rights decision, a state Supreme Court has banned the use of predictive policing tools by law enforcement statewide, citing the technology's racial bias and lack of transparency as unconstitutional. The court's ruling, delivered in a lawsuit brought by a coalition of community organizations, found that data-driven crime forecasting algorithms violate citizens' rights to due process and equal protection under the state's constitution. Police departments across the state have been ordered to terminate all predictive policing programs by July 1, 2026, making this the first statewide prohibition on the controversial technology and a major victory for algorithmic accountability advocates. What is predictive policing? Often likened to Minority Report-style crime prediction, predictive policing refers to software that analyzes historical crime data to predict future crime risks. These tools take in past crime statistics, such as time, location, and nature of offenses, and generate predictions about where crimes are likely to occur, sometimes displayed as hotspot maps, or even identify individuals who may be at higher risk of committing or becoming victims of crimes. The goal is to help police departments allocate resources more efficiently, for example, sending patrols to areas the algorithm flags as potential burglary hotspots at certain times of day, or conducting custom notifications with people whom the algorithm deems high risk. Takano.house.gov, Takano.house.gov. Rise and fall of an algorithmic trend. Early adoption. A decade ago, predictive policing was hailed as a cutting-edge innovation in law enforcement. Major cities including Los Angeles, Chicago, and New York piloted various systems. One of the first, Predpol, now rebranded as Geolytica, was tested in California and claimed it could algorithmically forecast crime locations by analyzing years of incident reports. Around the same time, Chicago developed a heat list of individuals at risk of gun violence using its own algorithm. These programs initially had strong support from some police leaders, who touted technology as a way to do more with limited budgets. CourthouseNews.com, CourthouseNews.com. Backlash and bias concerns. Almost as quickly, however, civil rights scholars and community activists raised alarms. They argued that predictive policing can perpetuate or even amplify racial bias, because the underlying data reflects historical over-policing of minority neighborhoods. If, for example, a certain neighborhood has seen more drug arrests in the past, perhaps due to targeted policing, a neutral algorithm might simply identify that area as a future crime hotspot, leading police to concentrate there again and make even more arrests. This feedback loop can create a self-fulfilling prophecy, where over-policed communities, often Black or Latino neighborhoods, continue to bear the brunt of law enforcement attention, while communities with similar crime rates,
but less police presence historically, are comparatively under-policed. CourthouseNews.com, CourthouseNews.com, Takano.house.gov, Takano.house.gov. Opacity and accountability. Another issue is that many of these tools are black boxes provided by private vendors, who typically refuse to disclose their proprietary algorithms or datasets. Police departments often sign confidentiality agreements that prevent them from revealing how the software works, even in court or to the public. This lack of transparency means defendants might not know if an arrest or investigation was prompted by an algorithmic prediction, nor can city officials or citizens fully scrutinize whether the system is accurate or fair. In 2018, for instance, the New York Police Department was compelled by a court to release documents about its predictive policing program, after legal pressure from civil liberties groups who argued that public oversight was impossible otherwise. The court's rationale: against this backdrop, a group of advocacy organizations, led by the local ACLU chapter, sued to stop the use of predictive policing in their state. The case eventually reached the state's highest court. In a sweeping opinion, the justices agreed that predictive policing systems threatened fundamental rights. First, the court cited evidence, including expert testimony and social science research, that these algorithms result in racially disparate policing, raising serious equal protection concerns. The justices noted that the plaintiff's evidence showed predictive tools repeatedly recommended heavier patrols in minority neighborhoods disproportionately to their crime rates, largely because of racially skewed historical data. This meant law-abiding residents in those areas were more likely to be stopped or surveilled simply because of where they live and long-standing biases in crime data. By relying on biased data, the court wrote, the tools inject racial bias into policing under the color of science, violating the guarantee of equal justice under law. CourthouseNews.com, CourthouseNews.com. Secondly, the court ruled that the opacity of the algorithms clashed with due process rights. In one instance, a defendant in a criminal case was seemingly flagged by a predictive system as a gang member and faced enhanced surveillance and charges as a result, yet neither he nor the court could access information on why the algorithm singled him out. The state Supreme Court held that when government uses secret algorithms to influence policing or prosecution, it undermines the transparency and fairness required by due process. This echoed broader concerns in the legal community, the idea that if a person's liberty is at stake, they have a right to understand the evidence or reasoning being used against them. The court's opinion underscored that, constitutionally, the state may not delegate its law enforcement powers to an unexamined algorithm that the public cannot question, especially when that algorithm's outputs suggest where to deploy force or whom to monitor. Implications for policing and tech companies. The immediate practical effect of the decision is that police departments across the state will have to dismantle or discontinue any predictive policing programs by this summer. Several cities in the state's metropolitan areas had employed such tools, often through pilot programs funded by federal grants. Those departments are now racing to replace what one police chief called another useful tool in our arsenal. Some options they're turning to include a return to traditional community policing strategies and increased hiring of officers to gather on-the-ground intelligence rather than relying on a computer's judgment. Training budgets may also need reallocation. Rather than investing in software, agencies might invest more in human-led analysis and community partnership programs that were previously deprioritized. The ruling is also sending shockwaves through the law enforcement technology industry. Companies that produce predictive policing software, along with related analytics firms like Palantir and others, have long insisted their products can be used without bias. They often point to measures like excluding certain data, e.g., avoiding the use of low-level drug arrest data, which might be especially prone to bias, and focusing on victim-driven crimes like burglaries or car thefts. For example, Predpol's CEO has claimed their software never uses racial or personal data and only predicts certain crimes to minimize bias. Despite such assurances, the court was not swayed, instead leaning on independent studies showing that even without explicit racial data, the choice of training data and the way an algorithm is tuned can reproduce inequities. Tech vendors now face a dilemma. To remain viable, they may need to make their algorithms far more transparent and bias-free, possibly subject to third-party audits or disclosure requirements. Otherwise, other jurisdictions could follow this state's example, either through litigation or legislation. KQED.org, KQED.org. Wider trend, tech in the justice system. This decision is the latest in a series of setbacks for unregulated use of AI and algorithms in policing and criminal justice. Several U.S. cities had previously banned specific technologies like facial recognition for law enforcement use. San Francisco was the first, in 2019, to outlaw police use of facial recognition due to accuracy and bias problems. Santa Cruz, California became the first city to ban predictive policing in 2020, with the local police chief himself admitting that predictive policing has been shown to put officers in conflict with communities rather than work with them. That city's leaders cited both racial bias and lack of independent validation of the tech as reasons for the ban. KQED.org. Other police departments, like Los Angeles's and Chicago's, have quietly shelved their predictive programs in recent years after internal assessments found mixed results and community pushback. In Los Angeles, the Inspector General reported in 2020 that the data-driven policing programs couldn't prove their effectiveness and had poor oversight, prompting the LAPD to cancel its contracts with Predpol and other vendors. KQED.org. Civil liberty advocates are hopeful that the state Supreme Court's ruling will be a model for other states or even federal courts. They argue it provides a roadmap for addressing not only predictive policing but other algorithmic tools in criminal justice, such as risk assessment scores used in bail and sentencing, that have shown evidence of bias. Indeed, lawyers from the NAACP and ACLU are already exploring whether similar constitutional arguments could be raised in states where police use algorithms to forecast crime or assess threat scores for individuals. On the law enforcement side, some officials have expressed frustration. The Fraternal Order of Police chapter in the affected state released a statement calling the ban a step backward, arguing that data analytics can help allocate police resources efficiently and that any tool can be misused if not properly managed. They urge state legislators to step in with a framework that would allow predictive policing with oversight, rather than a blanket ban. However, for now, the court's decision is binding, and the state's attorney general has pledged to enforce it, instructing all police agencies to certify by this summer that they have ceased using prohibited technologies. Bottom line, the ruling represents a significant victory for those concerned about algorithmic justice. It recognizes that advanced technology in law enforcement must be balanced with safeguards for civil rights. As one of the plaintiffs, a community advocate, said outside the courthouse, "We've been saying for years that these systems are biased. Today, the courts finally listened." The decision may mark a turning point, pushing policing to evolve in ways that don't rely on unaccountable algorithms, and prompting tech companies to develop more transparent, bias-tested tools if they want to regain the trust of both police and the public. $1.1 billion settlement reached in decades-long toxic water lawsuit. Record-setting environmental settlement. In one of the largest environmental settlements of its kind, a federal judge has approved a $1.1 billion agreement to resolve a mass tort lawsuit over groundwater contamination. The case involved a toxic chemical plume that seeped into the water table of several communities, allegedly caused by industrial waste from a now shuttered chemical manufacturing facility. The settlement will provide compensation to more than 40,000 residents who were exposed to contaminated water over the course of decades. While the defendant corporation continues to deny liability, it has agreed to the massive payout, which will fund medical screenings, cleanup efforts, and damages for affected families. Case background: the litigation centered on a groundwater pollution incident discovered in the early 2010s. Residents noticed odd tastes and odors in their well water, and an investigation revealed high levels of dangerous chemicals, specifically per- and polyfluoroalkyl substances, PFAS, and trichloroethylene, TCE, associated with a nearby manufacturing plant. These chemicals, sometimes called forever chemicals because they break down extremely slowly, had leached into the soil and aquifer over years of the plant's operation. Studies linked the contaminants to elevated cancer rates, thyroid disorders, and other serious health problems in the area. By 2016, dozens of lawsuits were filed by residents and property owners, and the cases were consolidated into a federal multi-district litigation, MDL, given the common facts. The plaintiffs alleged that the company knew about the contamination as early as the 1990s but failed to warn the public or properly dispose of hazardous waste. Internal documents unearthed during discovery indicated company engineers had flagged leaking chemical storage ponds years prior, according to plaintiffs' counsel, but little was done until regulators stepped in. The company, for its part, insisted it had followed industry regulations of the time and that other sources might have contributed to the pollution. Settlement terms: after a lengthy legal battle, including several early bellwether trials that resulted in multi-million-dollar verdicts for individual cancer victims, the parties reached the comprehensive settlement late last year. Key components of the agreement include compensation for individuals. A structured fund will pay out claims to more than 40,000 individuals who lived in the designated impact zone during the period of contamination. Payouts will be determined by factors such as length of exposure and severity of health effects, with maximum awards reserved for those who developed specific cancers linked to the chemicals. On average, individuals with documented health issues tied to the exposure could receive tens of thousands of dollars each, while those without manifested illnesses may receive smaller, nuisance awards or extended medical monitoring. Medical Monitoring Program. A substantial portion of the $1.1 billion will support a 40-year medical monitoring program to facilitate early detection of diseases related to the contaminants. Every class member is eligible for periodic medical tests, for example, blood tests for PFAS levels, cancer screenings, and thyroid function tests, at the expense of the fund, ensuring that any emerging health problems can be caught and treated as soon as possible. Courts have increasingly included such programs in toxic exposure settlements, acknowledging that some health effects may appear long after the exposure. Environmental remediation. The defendant will finance ongoing cleanup efforts in the region, including the installation of advanced filtration systems in water treatment plants and individual homes. The goal is to reduce chemical levels in the water supply to meet or exceed federal and state safety standards. An independent environmental monitor will oversee the cleanup and periodically report to the court and the public on progress. The settlement also requires the company to support the provision of alternative water sources, like bottled water or new water lines, until contamination is fully remediated, a process that could take years. No admission of liability. As is common in such settlements, the company admitted no wrongdoing as part of the agreement. In a statement, it maintained that it continues to dispute the claims brought against it but agreed that the settlement was in the best interest of the company and the community to resolve this matter and provide support to those impacted. By avoiding a trial, the company likely limits further legal costs and public relations damage, and plaintiffs secure relief more swiftly than if each case were litigated to verdict. Broader significance: this settlement is among the largest ever for a groundwater contamination case, on par with other major environmental payouts in recent memory. For comparison, in 2017, DuPont and Chemours paid $670 million to settle 3,550 lawsuits in Ohio and West Virginia over a different PFAS chemical, C8, that tainted local water supplies. In 2021, parties reached a $626 million settlement for the Flint, Michigan water crisis, compensating tens of thousands of residents exposed to lead-contaminated water. Just last year, 3M Company agreed to pay $10.3 billion to resolve claims by cities and towns across the U.S. for the costs of removing PFAS from public drinking water systems. That settlement, however, covers cleanup costs for water utilities rather than direct payments to individuals. In a similar vein, in 2025 a group of chemical companies, DuPont, Chemours, and Corteva, collectively agreed to an $875 million settlement with the state of New Jersey over PFAS contamination at former industrial sites, funds earmarked for environmental cleanup and health projects. The $1.1 billion settlement at issue here underscores a trend. Courts and companies are increasingly opting to settle sprawling environmental suits before they reach unpredictable jury verdicts that could be even costlier. The judge overseeing this MDL noted that the settlement will provide real and timely relief to communities harmed by corporate pollution, and commended both sides for avoiding further delay. For the residents who sued, many of whom attended the final fairness hearing, the settlement offers vindication and resources. This fight took nearly 15 years, but we finally have justice, said one plaintiff who developed kidney cancer after decades of using well water in the area. Still, some expressed frustration that the company did not admit liability. A community leader from one of the towns said, "Our town's been on bottled water for 8 years. No one should have to live in fear of their tap water." She and others hope the case will prompt stronger enforcement by regulators to prevent future disasters. Indeed, environmental advocates are calling for more proactive regulation of industrial chemicals, pointing out that PFAS were largely unregulated for years, which contributed to the problem. The Environmental Protection Agency has since set stricter health advisories for certain PFAS in drinking water and is moving toward establishing formal maximum contaminant limits. Corporate accountability in future cases. Large-scale toxic tort settlements like this also influence corporate behavior. The size of the payout, to be paid into a fund over several years, sends a message to industries that the cost of past environmental misdeeds can be staggeringly high. Shareholders have taken notice. The defendant company's stock price had been weighed down by uncertainty over this litigation, which was prominently noted in its SEC filings. By resolving the case, the company aims to turn the page on a reputational nightmare, though it still faces cleanup obligations and will be monitored by regulators. Other companies facing similar PFAS and contamination lawsuits, there are ongoing cases across dozens of states, will likely use this settlement as a benchmark in their own negotiations. Finally, this case highlights how communities can band together to seek redress. The 40,000 affected residents, many of whom lacked resources individually, were able collectively to hire top environmental lawyers and scientific experts. Through the class action and MDL process, they pooled evidence and resources, ultimately achieving a result that individual suits may not have accomplished. Our water may one day be clean again, and our people can get health checks. That's something to celebrate, the plaintiff's lead attorney said at a press conference. This settlement won't remove the toxic chemicals overnight, but it provides the funding and oversight to begin making it right. Viral Tenant Rights Pocketbook 2026 empowers renters nationwide. A $12 guide goes viral. A slim, self-published handbook on landlord-tenant law has become an unexpected bestseller and a social media sensation, giving renters across the country new tools to assert their rights. The Tenant Rights Pocketbook 2026, priced at just $12, contains a state-by-state breakdown of tenants' legal protections, presented in plain English. It covers critical topics like security deposits, evictions, lease terms, repair obligations, and anti-discrimination laws. Initially printed in a limited run by a coalition of tenant advocacy nonprofits, the pocketbook sold out within days after a TikTok video about it went viral. Now hard copies are being resold online for $50 or more, over 4 times the cover price, as renters scramble to get their hands on this newfound Know Your Rights resource. From obscure pamphlet to TikTok fame, the pocketbook's rise to prominence can be traced to a TikTok creator known as a tenant advocate, who regularly posts advice for renters. In late January, a tenant advocate shared a personal story of recovering a stolen security deposit using the pocketbook's guidance, dramatically brandishing the booklet on camera. The video struck a chord. Within 48 hours, it garnered over 2 million views and thousands of comments, mostly from tenants unaware of the rights they have. In the TikTok clip, the creator reenacted a confrontation with a landlord who had refused to return a $1,200 security deposit. Quoting from the pocketbook, which in turn cites New York's General Obligations Law Section 7-108, she informed the landlord that in New York, landlords must return security deposits within 14 days of a tenant moving out, providing an itemized list of any deductions, and that failure to do so can lead to double damages against the landlord. The next day, she received confirmation her deposit would be paid back in full. The video's message, "Know Your Rights," clearly resonated. Comments poured in from renters sharing their own struggles and small victories. Many asked where they could get the pocketbook. Demand soared. Guides content and approach. The Tenant Rights Pocketbook stands out for its accessible, jargon-free explanations. Each section is tailored to one state, listing key points such as how much a landlord can legally charge for a security deposit. Some states cap deposits at 1 or 2 months' rent, others have no cap. How quickly a landlord must return the deposit, e.g., 14 days in New York, 21 days in California, 30 days in Florida, etc. What grounds can justify eviction and what notice is required, and what remedies tenants have if landlords fail to meet their obligations, such as providing habitable living conditions or respecting privacy. It also includes sample letters and emails, for instance, a template for a repair demand citing a state's warranty of habitability law, and a form letter to use when a landlord doesn't return a security deposit on time. The creators, a group of legal aid attorneys and housing activists, say they were inspired by the many repeat questions they heard from renters. People would call our clinics asking, "Can my landlord do X? What do I do if Y happens?" said one co-author, an attorney with a tenants union. They realized a handy, pocket-sized guide could fill a major gap. After the viral TikTok, the team quickly scrambled to make a PDF version available online for free download to ensure access. Still, many have sought physical copies. The first print run of 5,000 booklets sold out in a weekend, and opportunistic resellers listed copies on eBay at steep markups, some for as high as $75, with listings emphasizing the item's sudden rarity. The publishers have since announced a second print run of 25,000 copies. Empowering renters, real-world impact. The surge in popularity of the pocketbook appears to be translating into tangible action by tenants. Enforcing security deposit rights. One pervasive issue for renters is getting back security deposits. Many states have strict rules. For example, if a landlord in California doesn't refund a deposit within 21 days of lease termination and provide an itemized deduction list, they forfeit the right to withhold any of the deposit, except for repair costs backed by receipts. The pocketbook summarizes these rules for each state. Tenant forums are now filled with stories of readers using the guide's form letters to demand their deposits. A legal aid organization in Texas reported a spike in inquiries from tenants who, armed with the pocketbook, are successfully recovering deposits or threatening small claims court if landlords don't comply with state deadlines. Fighting illegal evictions. Eviction law is notoriously complex and varies by locale. The pocketbook details that no tenant can be evicted without a court order. Self-help evictions like changing locks or shutting off utilities are illegal in every state. It also outlines typical notice requirements, e.g., a 30-day notice for month-to-month tenants in many states, and what defenses tenants can raise in eviction court, such as a landlord's failure to maintain the property in habitable condition. Tenant advocates say awareness is half the battle. We've had clients come in with eviction notices who didn't realize they had a right to a hearing, a housing counselor in Chicago noted. Now, more people are showing up to court and contesting wrongful evictions, often winning more time to relocate or getting eviction filings sealed. Social media has played a role. Following the pocketbook's viral moment, TikTok and Reddit users have shared tips on navigating eviction court, sometimes referencing the guide for state-specific rules on things like eviction diversion programs or grace periods for late rent. Demanding repairs in habitable conditions. The pocketbook extensively covers the warranty of habitability, a legal doctrine requiring landlords to maintain rental properties in livable condition, working plumbing, heat, no serious infestations or hazards, etc. It instructs tenants on how to document issues and request repairs in writing, citing local housing codes. Many renters have posted success stories. One viral tweet described how a landlord fixed a persistent mold problem after the tenant referenced the state health code and the possibility of escrow, paying rent into a court account until repairs are made, a right in several states. The heightened knowledge of rights is also leading to collective action. In at least 2 cities, Philadelphia and Atlanta, tenants have formed online groups to share pocketbook information and coordinate rent strikes or group complaints in buildings with negligent landlords. Reactions. Landlord groups. Some landlord associations have reacted warily to the pocketbook's popularity. They worry that an adversarial tone could strain landlord-tenant relationships. A spokesperson for a statewide apartment association said that while educating tenants is positive, we hope the pocketbook also encourages dialogue and not just legal threats. Most landlords want to do the right thing, and open communication can resolve many issues without courts. Landlords are also arming themselves with knowledge. Some property management firms have reportedly purchased the pocketbook to better understand the evolving rights of tenants and ensure compliance. It's actually a useful checklist for us too, admitted one landlord in Florida. If we follow all these rules, we stay out of trouble. Tenant advocates and officials. Renters' rights organizations are celebrating the nationwide attention. They note that housing laws are only effective if people know about them. In many jurisdictions, more than half of tenants facing eviction still go to court without legal representation, often unaware of defenses available to them. A viral product like the pocketbook, coupled with short, catchy social media explainers, is seen as a game changer. Some legal aid groups are now partnering with the pocketbook's creators to distribute free copies to at-risk renters, funded by charitable donations. Even government agencies have taken note. The Consumer Protection Office in one state is considering adapting the pocketbook's content for official use, and a major city's housing department shared the TikTok video, urging residents to learn about their rights. Larger context, a housing crunch. The backdrop to this phenomenon is a national housing affordability crisis.
With rents near record highs in many cities and pandemic-era eviction moratoriums expired, tenant-landlord tensions are on the rise.
States like California and Oregon have passed new laws capping rent increases and providing eviction protections, but enforcement often relies on tenants knowing and asserting those rights. The Tenant Rights Pocketbook 2026 arrived at a perfect moment, riding a wave of grassroots housing activism and online engagement. It underscores how social media can democratize legal knowledge, complex statutes and leases can be translated into relatable content, sometimes even memes or skits, that spread to millions. For many tenants, that knowledge can mean the difference between being intimidated into unfair terms versus pushing back and seeking assistance. As one renter wrote in a review of the pocketbook, "This little book turned out to be my biggest source of power. Now I know, I have rights, and I'm not afraid to use them."
Vintage law textbooks from the 1980s become hot collector's items.
Old casebooks gain new life. In a curious trend blending nostalgia and legal history, first edition law school casebooks from the 1980s are now fetching prices as high as $300 to $350 on resale markets, roughly 8 times their original price.
Once thought to be almost valueless after newer editions replaced them, these aging tomes have become sought-after collectibles among some lawyers, academics, and book collectors. A first edition casebook that might have sold for $40 in 1985 could now command well over $300 if in good condition. Collectors cite a mix of factors driving the trend: the historical significance of these editions, the influence of their famous authors, nostalgia for the collector's own law school days, and even the aesthetic appeal of richly bound old law books on office shelves. Why collect 1980s casebooks?
Unlike centuries-old legal treatises, such as Blackstone's 1760s commentaries, which can sell for tens of thousands of dollars to rare book collectors, the casebooks of the late 20th century are just old enough to be considered vintage but modern enough to be relevant to today's lawyers. Many of the most prized items were authored by luminaries who have since become legends in the field. Constitutional Law, First Edition, mid-1980s, by Lawrence Tribe, a renowned Harvard law professor and constitutional scholar, influenced generations of lawyers. His early edition casebooks, complete with his original commentary on landmark cases of the time, are now collector favorites. On online marketplaces, sellers highlight these books' historical perspective on constitutional issues like school desegregation, affirmative action, and executive power during the Reagan era. Torts, First Edition, 1983, by Prosser, Wade and Schwartz. The Prosser name has been synonymous with tort law for decades. William Prosser's earlier treatise shaped American tort doctrine. The 1980s first casebook editions updated by his successors capture tort law as it evolved post-Prosser. Collectors appreciate features like now omitted cases and commentary discussing emerging theories of product liability and negligence law in the 80s. A well-preserved copy of the 1984 Prosser and Keaton on Torts, 5th edition, which integrated 1980s developments, was recently listed at $320 on eBay, a steep premium over its original price. Federal Courts, 2nd edition, 1985, by Henry Hart and Herbert Wexler. The Hart and Wexler's Federal Courts casebook is a staple in law schools, and early editions from the 1980s reflect a time when foundational questions about federal versus state court jurisdiction were being debated in new ways. With the authors now deceased, Hart and Wexler's work is carried on by new editors in later editions. Owning a first or second edition has become a way for legal scholars to connect with the roots of modern federal courts jurisprudence. Enthusiasts say these books offer a time capsule of legal thought. At a recent online auction, a bidder paid over $300 for a first edition criminal procedure casebook, 1986, just to compare its treatment of Fourth Amendment law with today's casebooks. It's fascinating to see how much has changed, and what's remained the same, in how we teach criminal law, the buyer said. Some notable differences: a 1980s criminal procedure book might barely mention digital privacy, whereas a 2026 edition devotes entire chapters to cell phone searches and internet surveillance. Likewise, an old casebook on constitutional law predates major decisions like Obergefell v. Hodges, 2015, legalizing same-sex marriage, offering insight into how earlier generations approached issues like gay rights. Nostalgia and professional pride. Many buyers are seasoned attorneys or judges who attended law school in the 1980s. For them, acquiring a first edition casebook is personal. "I just bought the same contracts casebook I had on my 1L desk in 1984, said a senior partner at a law firm, who found a copy on a legal memorabilia site. It even smells like law school, he joked, noting the marginalia in his newly acquired book was strikingly similar to notes he once took. Displaying these books in offices or home libraries has become a subtle status symbol in certain legal circles, signaling deep roots in the profession. Some lawyers have the casebooks signed by their former professors, or by any of the famous co-authors still living, and then proudly showcase them. Market dynamics. The mini-market for vintage casebooks seems to have emerged spontaneously. Specialized retailers and online marketplaces have taken note. At least one website now bills itself as a rare and used law books marketplace, listing older law texts and casebooks for sale to collectors. Sellers with foresight who held onto first editions of casebooks by prominent authors find themselves with surprising windfalls. One Manhattan rare bookstore reported selling a 1980 first edition of a corporate law casebook for $250. On eBay, listings for 1970s 80s law textbooks that might once have fetched $5 to $10 as used books are now being advertised as collectible vintage law books at 10 to 20 times those prices, though it's unclear how many actually sell at that level. Two specific categories of 1980s law books are especially popular. Casebooks associated with Supreme Court justices or famous judges. If a casebook author later became a judge or justice, interest spikes. For example, the late Justice Ruth Bader Ginsburg co-authored a civil procedure textbook in the 1960s. Original copies of those earlier editions saw increased demand after she joined the Supreme Court. In the 1980s context, one of the federal court's casebooks was co-authored by future Justice Antonin Scalia, the 1987 Hart and Wexler Supplement. Such volumes attract both law aficionados and Supreme Court memorabilia collectors. Out-of-print legal theories or commentary. Some early editions contain notes or perspectives that were removed in later updates. Collectors and academics value these as snapshots of how legal thinking has evolved. For instance, a first edition 1980s casebook on women and the law might include discussions of then nascent legal theories of gender discrimination, providing historical context on how feminist legal scholarship took root in curricula. Cultural reflections. At a broader level, this trend speaks to the legal profession's connection to its own history. In an era when law students increasingly use digital casebooks and online resources, the allure of these old physical books is partly sentimental, partly pedagogical. They remind lawyers of countless hours spent poring over pages in law libraries. They also serve as a counterbalance to the digital age. As one collector put it, in the digital era, having the actual book feels more meaningful. It's like holding a piece of legal history. Some have compared it to the revival of vinyl records among music enthusiasts, a desire to own the classic format, even if the content is available in modern form. Law professors have chimed in as well. Some encourage the trend insofar as it highlights the intellectual heritage of legal fields. The casebook is an American invention that revolutionized legal education in the 20th century, noted a legal historian, referring to Harvard's Christopher Columbus Langdell, who pioneered case-based teaching in the 1870s. Collecting old casebooks is not just book hoarding, it's preserving the evolution of legal education. While this niche market may remain small, law book dealers anticipate continued interest as long as the legal profession maintains a reverence for its past. And with many 1980s-era lawyers now approaching retirement, some are downsizing and parting with their old textbooks, thus feeding the supply of vintage casebooks into the market, where younger attorneys or libraries may eagerly snap them up. Whether this is a passing fad or a lasting segment of the book collecting world remains to be seen. But for now, that dusty first edition casebook on your shelf might be worth more than you think, historically and financially. Sources. Provide your feedback on BizChat. Disclaimer: this report is for informational purposes only and does not constitute legal, financial, or medical advice. The news stories presented are anecdotal and should not be interpreted as guidance or recommendations. Major legal news stories, February 14, 2026. Supreme Court and federal court rulings, key decisions issued today. The United States Supreme Court and federal appellate courts have issued several significant opinions and orders in the past 24 hours, shaping the legal landscape on criminal justice, election law, and constitutional rights. These decisions not only resolve high-profile disputes but also set precedents that will influence lower courts and public policy nationwide. Supreme Court, recent opinions and their implications. Among the most closely watched opinions released this week, the Supreme Court addressed issues ranging from criminal sentencing to election administration. In Klein v. Martin, the court examined the admissibility of forensic evidence and the standards for ineffective assistance of counsel in a Maryland attempted murder case. The majority opinion, authored by Chief Justice Roberts, clarified the threshold for introducing homemade devices as evidence and reinforced the requirement that defense counsel must investigate all plausible lines of defense. Legal analysts note that this decision may lead to increased scrutiny of forensic evidence in state courts and could prompt new appeals in cases involving questionable expert testimony. In Bost v. Illinois Board of Elections, the court upheld Illinois' practice of counting mail-in ballots postmarked by Election Day but received up to 2 weeks later. The majority reasoned that the state's approach did not violate federal election law or the Equal Protection Clause, emphasizing the importance of accommodating voters who rely on mail-in voting. This ruling is expected to influence ongoing litigation in other states where similar deadlines are being challenged, especially as the 2026 midterm elections approach. Legal experts from the American Bar Association and the Brennan Center for Justice have largely praised the court's reaffirmation of voter access, though some conservative commentators argue that the decision could open the door to post-election disputes over ballot validity. The court's election law docket remains active, with several cases on redistricting and voting rights scheduled for oral argument in the coming months. Federal courts, notable district and appellate decisions. Federal district and appellate courts have also issued impactful rulings this week. In a high-profile case from the Eastern District of Pennsylvania, the court dismissed municipal liability claims against the city of Philadelphia in a wrongful death suit involving an inmate's overdose, finding insufficient evidence of a deliberate policy of understaffing that would support constitutional liability. Meanwhile, a federal judge in California granted a preliminary injunction against a city ordinance restricting cannabis billboard advertisements, holding that such restrictions likely violate commercial speech rights under the First Amendment. In Alaska, a class of incarcerated individuals was permitted to proceed with a lawsuit against the state's Department of Corrections over inadequate healthcare, with the court finding that prior settlements did not bar new claims focused on current harms. These cases reflect the judiciary's ongoing engagement with issues of prisoner rights, public health, and the boundaries of municipal authority. Legal commentators have noted that these decisions collectively underscore the court's willingness to scrutinize government practices affecting vulnerable populations, while also emphasizing the procedural rigor required to establish liability under federal civil rights statutes. Immigration enforcement, ICE detention, and judicial rebukes. Immigration enforcement and the conduct of Immigration and Customs Enforcement, ICE, remain at the center of legal controversy, with federal courts across the country issuing a wave of rulings against the Trump administration's mass detention strategy. Judges have repeatedly found ICE in violation of court orders, raising constitutional concerns and prompting calls for systemic reform. Judicial frustration with ICE noncompliance. A comprehensive review of hundreds of cases reveals a pattern of ICE slow-walking or outright defying judicial orders to release detainees, even after courts have found their detention unlawful. Judges have documented instances where ICE rapidly transferred detainees across state lines to thwart legal proceedings, delayed releases for days or weeks after court orders, and released individuals without their belongings or in unsafe conditions. In Minnesota, where the administration's enforcement efforts have been most aggressive, federal judges have issued increasingly detailed and prescriptive orders to ensure compliance, including requirements that detainees be released in their home state with all personal effects and without restrictive monitoring devices. U.S. District Judge Jerry Blackwell, among others, has publicly rebuked ICE for what he described as constitutional injury inflicted on lawfully present individuals. Judges have threatened contempt proceedings against ICE officials and, in some cases, personally monitored the return of detainees' documents. The judiciary's frustration is palpable, with Chief Judge Patrick Schultz of Minnesota and Judge John Tunheim emphasizing the need for humane treatment and adherence to due process. Constitutional and policy implications. The legal conflict centers on the administration's use of mass detention without individualized bond hearings, a practice that courts have overwhelmingly rejected as inconsistent with due process. Despite thousands of rulings in favor of detainees, ICE has continued to pursue its strategy, prompting judges to accuse the agency of wasting judicial resources and taxpayer money. The Department of Justice has cited communication breakdowns and an overwhelming caseload as contributing factors but maintains that it is enforcing federal law. Legal scholars warned that the ongoing standoff between the judiciary and ICE threatens the rule of law and undermines public confidence in the immigration system. Civil rights organizations have called for congressional oversight and legislative reforms to ensure compliance with court orders and protect the rights of non-citizens.
Institutional and expert reactions.
Homeland Security officials have defended the use of monitoring devices and rapid transfers as necessary enforcement tools, but have not directly addressed the judiciary's complaints. Legal experts from the American Immigration Lawyers Association and the National Immigrant Justice Center have praised the court's assertiveness but cautioned that systemic change will require both executive and legislative action.
The situation remains fluid, with new cases and judicial orders emerging daily.
The legal community is closely watching whether the administration will adjust its enforcement tactics or continue to test the limits of judicial patience. Department of Justice actions, university investigations and civil rights enforcement. The Department of Justice, DOJ, has been active on multiple fronts, announcing new investigations, enforcement actions, and high-profile indictments. These developments reflect shifting priorities under the current administration and ongoing debates over the scope of federal civil rights enforcement.
DOJ investigation into Lincoln Memorial University.
On February 13, 2026, the DOJ's Civil Rights Division, in partnership with the Department of Health and Human Services, launched a formal investigation into Lincoln Memorial University, LMU, in Tennessee. The probe seeks to determine whether LMU's DeBusk College of Osteopathic Medicine engaged in discrimination against Jewish students, specifically by allegedly preventing them from completing exams during the spring semester. The investigation is being conducted under Title VI of the Civil Rights Act of 1964 and Section 1557 of the Affordable Care Act, both of which prohibit discrimination on the basis of race, color, or national origin by recipients of federal funds. Assistant Attorney General Harmeet K. Dillon emphasized the DOJ's commitment to combating anti-Semitism on college campuses, citing a broader federal crackdown in response to rising incidents since October 2023. The university has stated that it upholds federal non-discrimination laws and will cooperate with the investigation, though it has not addressed the specific allegations. The outcome of this inquiry could have significant implications for federal oversight of higher education institutions and the enforcement of civil rights protections for minority students. DOJ lawsuit against Harvard University. In a separate action, the DOJ filed suit against Harvard University for allegedly withholding race-related admissions documents. The case, announced on February 13, 2026, signals the administration's intent to scrutinize elite universities' compliance with federal civil rights laws in the wake of recent Supreme Court decisions limiting the use of race in admissions. Legal analysts suggest that the outcome of this litigation could set important precedents for transparency and accountability in higher education. Civil Rights Division staffing crisis and policy shifts. Reports indicate that the DOJ's Civil Rights Division, particularly its criminal section responsible for investigating law enforcement misconduct, has experienced a dramatic reduction in staffing, losing nearly two-thirds of its prosecutors over the past year. New internal directives have limited the unit's mandate to only the most egregious cases, such as those involving sexual assault or death in custody, effectively deferring most investigations of police excessive force to state and local authorities. This policy shift has already impacted high-profile cases, with the DOJ declining to pursue a civil rights probe into the fatal shooting of Renee Good by federal agents, while downplaying the scope of its investigation into the killing of Alex Preddy. Former prosecutors and civil rights advocates warn that the reduced capacity threatens the consistent application of federal law and undermines public trust in the DOJ's ability to hold law enforcement accountable. The administration maintains that it continues to prosecute violations aggressively, citing recent actions against hate crimes. However, critics argue that the exodus of veteran lawyers and the narrowed mandate have compromised the division's effectiveness. The future of federal oversight in law enforcement practices remains uncertain, with legal experts calling for congressional hearings and potential legislative remedies. Government shutdown and federal funding, legal developments and impacts. The federal government is once again grappling with a partial shutdown, as funding for the Department of Homeland Security, DHS, lapsed at midnight on February 14, 2026. The impasse centers on contentious negotiations over immigration enforcement reforms, with Democrats demanding new restrictions on ICE operations and Republicans insisting on robust law enforcement measures. Shutdown details and agency impacts. The current shutdown marks the third lapse in federal funding since October 2025, following a record 43-day shutdown last fall and a shorter disruption in January. Key DHS agencies affected include the Transportation Security Administration, TSA, the Federal Emergency Management Agency, FEMA, the Cybersecurity and Infrastructure Security Agency, CISA, the U.S. Secret Service, and the U.S. Coast Guard. While more than 90% of DHS employees are deemed essential and will continue working, many will do so without pay, and critical operations such as disaster reimbursements and cyber protections face delays. ICE, however, will largely continue operating due to a $75 billion infusion provided in last year's One Big Beautiful Bill, insulating immigration enforcement from the immediate effects of the shutdown. This has fueled further debate, as Democrats push for judicial warrants before agents can enter private property, bans on face masks for ICE agents, mandatory body cameras, and new use of force standards. Negotiations are ongoing, with President Trump pledging personal involvement and Democrats vowing to secure ironclad legislative changes. Legal and political implications. The shutdown has reignited debates over the separation of powers and the limits of executive authority in federal spending. Legal experts note that while Congress holds the power of the purse, the administration's ability to shield certain agencies from funding lapses raises questions about accountability and oversight. The standoff also highlights the challenges of enacting substantive policy reforms through appropriations bills, a practice that has become increasingly common in recent years. Public sector unions and advocacy groups have warned of the long-term consequences for federal workers and the delivery of essential services. The legal community is closely monitoring court challenges that may arise if the shutdown persists or if agencies attempt to circumvent statutory funding restrictions. State law and regulatory changes effective in 2026. A wave of new state laws took effect on January 1, 2026, reshaping the legal landscape in areas such as wages, employment rights, consumer data protection, artificial intelligence, healthcare, housing, and more. These measures reflect the growing role of states in setting practical standards amid limited federal action. California wage, employment, and healthcare reforms. California's minimum wage increased to $16.90 per hour, with higher rates in major cities such as Los Angeles and San Francisco. The minimum salary for exempt employees rose to $70,304 annually, and industry-specific thresholds were updated for fast food and technology workers. Employers face expanded obligations under the state's WARN Act for mass layoffs, new requirements for providing working stoves and refrigerators in rental units, and an expanded plastic bag ban. A landmark healthcare reform capped insulin copayments at $35 per month for many state-regulated health plans, with the rollout of CalRx-branded insulin at lower list prices. The American Diabetes Association praised the measure as one of the strongest patient protection laws in the country, benefiting approximately 3.5 million Californians with diabetes. California also enacted new oversight rules requiring private equity and hedge fund investors in healthcare to file disclosures, expanded consumer protections related to debt collection, and clarified eviction and trespass rules to protect minors. Artificial intelligence regulation, California, Texas, Colorado. California's AI Transparency Act and companion laws impose phased-in transparency and child safety provisions, requiring manifest and latent disclosures in AI-generated content and new safeguards for companion chatbots. The state's companion chatbot law mandates protocols to prevent chatbots from engaging in conversations about suicidal ideation or sexually explicit content with minors, recurring alerts to remind users they are interacting with AI, and annual reporting to the Office of Suicide Prevention. Texas's Responsible Artificial Intelligence Governance Act prohibits discriminatory AI applications, establishes an advisory council and regulatory sandbox, and sets transparency standards for government AI deployments. Colorado's Artificial Intelligence Act, effective mid-2026, imposes risk-based obligations on developers and deployers of high-risk AI systems, including impact assessments and anti-discrimination safeguards. Legal experts note that these state laws create a patchwork of AI regulation, prompting concerns about compliance burdens and the potential for federal preemption. Data privacy, Indiana and Kentucky. Indiana's Consumer Data Protection Act, effective January 1, 2026, grants residents the right to access, correct, delete, and opt out of certain data processing. The law applies to businesses meeting specified data processing thresholds and is enforced by the Attorney General, with penalties of up to $7,500 per violation. Kentucky's similar law includes a permanent cure provision allowing businesses to remedy alleged violations. These developments reflect a broader trend of states enacting comprehensive privacy laws in the absence of federal legislation, with implications for businesses operating nationwide. Other notable state laws: New York, minimum wage increases, delivery worker protections, and expanded outreach against immigration services fraud. Illinois, job-protected neonatal intensive care unit leave, expanded paid organ donation leave, and safe gun storage requirements. Minnesota, clarified rules on meal and rest breaks, restroom access, and alignment of local sick and safe time ordinances. Oregon and Washington, new rules related to strike benefits and expanded unemployment eligibility for striking workers. Legal analysts emphasize that these state-level changes will significantly impact employers, consumers, and service providers, requiring proactive compliance and adaptation to evolving standards. High-profile resignations and law firm fallout from Epstein files. The release of millions of documents related to convicted sex offender Jeffrey Epstein continues to reverberate across the legal, business, and academic worlds. High-profile resignations, firings, and institutional reviews have accelerated as the files are dissected and scrutinized. Major departures and institutional responses. Kathy Ruemmler, a top lawyer at Goldman Sachs and former White House counsel, announced her resignation after email correspondence revealed a relationship with Epstein. Ruemmler cited media attention and distraction as reasons for her departure, though she maintains that her interactions were professional and regrets ever knowing Epstein. Goldman Sachs has emphasized its commitment to ethical standards and transparency. Brad Karp, chair of the prominent law firm Paul, Weiss, Rifkind, Wharton and Garrison, stepped down following the disclosure of emails with Epstein. While some media outlets portrayed this as a dramatic fall from grace, legal insiders suggest that Karp's departure was part of a planned succession and that he remains a partner at the firm. The episode has sparked debate over accountability and the tolerance of elite law firms for controversial relationships, with critics arguing that meaningful change remains elusive. Other notable figures affected include Lee Smolin, a renowned physicist at the University of Waterloo, who paused his working relationship with the university, Sultan Ahmed bin Sulayem, head of Dubai's DP World, who was replaced after lewd exchanges with Epstein were revealed, and Peter Mandelson, a UK Labour peer, who resigned from the party in the House of Lords. Investigations and reviews are ongoing at institutions such as the World Economic Forum and the NFL, reflecting the global reach of the Epstein files. Political and legal context. The fallout has fueled political debates over the wisdom and expense of the Epstein Files Transparency Act, with lawmakers seeking to justify the law amid public demand for accountability. Media coverage has highlighted the distinction between criminal misconduct and mere association, cautioning against overinterpretation of the released documents. Legal experts note that while the disclosures have led to reputational damage and institutional reviews, concrete evidence of criminal wrongdoing by high-profile individuals remains limited. The situation underscores the challenges of balancing transparency, due process, and the presumption of innocence in high-stakes investigations. DOJ criminal prosecutions and major indictments. The Department of Justice has announced several major indictments and convictions in the past week, targeting organized crime, drug trafficking, racketeering, and financial fraud. Organized crime and racketeering. A federal jury in Memphis convicted 2 members of the Unknown Vicelords, UVL, street gang for racketeering murder, following a 1-week trial. The DOJ also unsealed a 38-count indictment charging 27 members of the anti-Tren faction of the Tren de Aragua organization with offenses including racketeering conspiracy, murder, kidnapping, and sex trafficking in connection with a double murder in New York. In Seattle, a wiretap investigation led to the indictment of 14 individuals associated with a Tacoma street gang involved in manufacturing counterfeit narcotic pills, drug trafficking, and firearms offenses. Authorities seized 38 firearms, over 100 machine gun conversion devices, and $1.5 million in cryptocurrency allegedly used to launder drug proceeds. The investigation linked the group to multiple overdose deaths and violent assaults, underscoring the DOJ's focus on dismantling violent criminal enterprises.
Financial fraud and tax crimes.
The DOJ secured a preliminary injunction against Orlando area tax return preparers accused of preparing fraudulent returns, and convicted 5 defendants in Miami for a sophisticated scheme involving stolen mail keys and counterfeit checks. Additional convictions were announced in cases involving drug trafficking, bank fraud, and embezzlement from union funds. Legal analysts highlight the DOJ's continued emphasis on prosecuting complex financial crimes and organized criminal activity, with multi-agency task forces playing a key role in recent successes. Regulatory rollbacks and executive actions. The Trump administration has continued its deregulatory agenda, issuing executive orders and final rules that roll back or modify regulations across multiple sectors. AI regulation, Federal Preemption and Litigation Task Force. On December 11, 2025, President Trump signed an executive order establishing a national policy framework for artificial intelligence. The order creates an AI litigation task force to challenge state AI laws deemed inconsistent with federal priorities and advances the development of federal standards for reporting, disclosure, and consumer protection. The order aims to preempt conflicting state laws while preserving state authority in areas such as child safety and government use of AI. Legal experts note that the order signals a shift toward federal supremacy in AI regulation, raising questions about the future of state-level initiatives and the potential for litigation over preemption and constitutional issues.
Healthcare law, VA reproductive health services rollback.
The Department of Veterans Affairs finalized a rule reinstating exclusions on abortion and abortion counseling from its medical benefits package in the CHAMPA program, effective January 30, 2026. The rule follows a DOJ Office of Legal Counsel opinion concluding that the VA lacks statutory authority to provide abortion services, except in cases where the life of the mother is endangered. The VA received over 24,000 public comments, with many expressing concern about the impact on veterans' health and access to care.
The agency emphasized that life-saving treatment remains covered and that the rule aligns with other federal programs restricting abortion funding. Immigration and Employment, H-1B and EAD changes.
The Department of Homeland Security finalized a rule implementing a weighted selection process for H-1B visa petitions, favoring higher-paid foreign workers. The agency also ended the practice of automatically extending employment authorization documents, EADs, upon renewal application, requiring individuals to secure approval before their work authorization expires. These changes are expected to impact employers and foreign workers, with legal analysts predicting increased litigation over the new selection criteria and potential labor shortages in certain sectors.
Consumer protection, medical debt and data privacy.
The Consumer Financial Protection Bureau issued an interpretive rule clarifying that the Fair Credit Reporting Act preempts state laws banning the use of medical debt in credit reporting, reversing a 2022 interpretation that allowed states to impose such bans. Indiana and Kentucky's new consumer data protection laws grant residents expanded rights over their personal data, with enforcement by state attorneys general and significant penalties for non-compliance.
Election law and voting-related court decisions.
Legal battles over election administration, redistricting, and voting rights continue to shape the 2026 election landscape. The Trump administration's efforts to nationalize elections have been met with resistance from states and the courts, with federal judges in California, Michigan, and Oregon rejecting demands for unredacted voter registration lists and other election-related records.
Key court rulings and ongoing litigation.
Federal courts have blocked executive orders requiring proof of citizenship for voter registration, prohibiting the use of certain voting equipment, and conditioning federal funding on compliance with new voting system guidelines.
In Oregon and California, judges have barred the federalization of the National Guard for election-related purposes, citing violations of the 10th Amendment and statutory requirements for deploying federal troops. Redistricting cases remain active, with the Supreme Court set to rule on challenges to congressional maps in Louisiana, Texas, and California. State courts are also hearing disputes over ballot measures, judicial elections, and the administration of new district boundaries.
Legal experts emphasized the critical role of state courts in resolving election-related litigation and ensuring the integrity of the electoral process.
Institutional and expert reactions.
Election law scholars and advocacy groups have praised the judiciary's defense of state authority and voter access, while warning of the risks posed by federal overreach and partisan manipulation of election rules. The legal community is preparing for a surge of litigation as the 2026 midterms approach, with heightened scrutiny of voting procedures, ballot access, and the use of technology in elections. AI regulation and legal challenges, federal-state tensions. The regulatory landscape for artificial intelligence is rapidly evolving, with states enacting new laws and the federal government asserting preemption through executive action. State laws and federal preemption. California's Transparency and Frontier Artificial Intelligence Act, Texas's Responsible Artificial Intelligence Governance Act, and Colorado's AI Act impose a range of obligations on AI developers and deployers, including transparency, risk assessments, and anti-discrimination measures. However, President Trump's executive order seeks to establish a uniform federal framework, preempting state laws deemed inconsistent with national policy. The order directs the creation of an AI litigation task force and conditions federal funding on states' avoidance of onerous AI laws. Legal analysts predict a wave of litigation over the scope of federal preemption, the constitutionality of compelled disclosures, and the balance between innovation and consumer protection. Businesses operating across state lines face a complex compliance environment, with the potential for conflicting requirements and enforcement actions. Child safety and AI, California's companion chatbot law. California's new law regulating companion chatbots requires platforms to implement protocols to prevent harmful interactions with minors, including recurring alerts, content restrictions, and annual reporting to the Office of Suicide Prevention. The law reflects growing concerns about the impact of AI on children's mental health and the need for robust safeguards in emerging technologies. Industry groups have expressed concern about the compliance burden and the risk of stifling innovation, while child advocacy organizations have praised the state's leadership in protecting vulnerable users. The legal community is closely monitoring the implementation of these laws and the potential for federal intervention. Healthcare law updates, insulin pricing and VA reproductive rules. Healthcare law continues to evolve at both the state and federal levels, with significant developments in drug pricing and reproductive health services. Insulin copay cap in California. California's new law capping insulin copayments at $35 per month for state-regulated health plans has been hailed as a major victory for patients and advocates. The American Diabetes Association estimates that the law will benefit millions of Californians, reducing financial barriers to essential medication and setting a precedent for other states to follow. The law also requires insurers to ensure that at least one insulin for each drug type is included on prescription drug formularies, further expanding access. VA Reproductive Health Services rollback. The Department of Veterans Affairs' final rule reinstating exclusions on abortion and abortion counseling has sparked intense debate. While the VA cites statutory limitations and a binding DOJ opinion as the basis for the rule, critics argue that the rollback will harm veterans, particularly women and those in rural areas. The VA has emphasized that life-saving treatment remains covered and that the rule aligns with other federal programs restricting abortion funding. Legal challenges are expected, with advocacy groups preparing to contest the rule on constitutional and administrative grounds. Labor and employment law, new protections and litigation. States continue to expand workplace protections, increase enforcement authority, and raise the stakes for non-compliance. California's new laws include expanded pay transparency requirements, enhanced penalties for unpaid wage judgments, and new restrictions on stay-or-pay agreements that require employees to repay training or relocation costs upon termination. The state has also extended COVID-19 recall and reinstatement obligations for certain hospitality and service workers, and clarified driver classification standards in the transportation sector. Employers are advised to review policies, update compliance procedures, and conduct audits to mitigate litigation risk. Legal experts predict increased enforcement activity and a rise in class action lawsuits as employees and regulators test the boundaries of new protections. Notable appellate and district court cases to watch. Legal observers are tracking several appellate and district court cases with the potential to set important precedents in public health, criminal justice, and civil rights. Los Angeles Angels settlement. The baseball franchise settled a wrongful death lawsuit over a pitcher's overdose, with the terms remaining confidential but the case highlighting employer liability for employee health and safety. Alaska incarcerated individuals. A class action over inadequate healthcare in state prisons proceeds, with the court finding that prior settlements do not bar new claims focused on current harms. DEA officer indictments. Former DEA officials face charges for bribery, drug trafficking, and money laundering, including alleged assistance to the Jalisco New Generation cartel. Opioid litigation. West Virginia filed suit against pharmacy benefit manager Optum, alleging conspiracy to fuel the opioid crisis, while Amneal Pharmaceuticals reached a nationwide settlement to resolve opioid-related claims. These cases reflect the judiciary's ongoing engagement with complex issues at the intersection of public health, criminal justice, and corporate accountability. International law, extradition and foreign criminal cases. The Trump administration announced the capture and extradition of Zubair al-Bakush, a Libyan national accused of participating in the 2012 Benghazi attack that killed 4 Americans. Al-Bakush faces an 8-count indictment including murder, attempted murder, and material support for terrorism. Attorney General Pam Bondi and FBI Director Kash Patel emphasized the administration's commitment to pursuing justice for victims of terrorism, while legal analysts note the challenges of securing convictions in high-profile international cases. The extradition underscores the ongoing cooperation between U.S. and foreign law enforcement agencies and the complexities of prosecuting crimes committed abroad. Privacy, data protection, and consumer law developments. Indiana's Consumer Data Protection Act, effective January 1, 2026, grants residents expanded rights over their personal data, including the right to access, correct, delete, and opt out of certain processing. The law applies to businesses meeting specified thresholds and is enforced by the Attorney General, with significant penalties for non-compliance. Kentucky's similar law includes a permanent cure provision for alleged violations. Legal experts advise businesses to review data processing practices, update privacy notices, and implement robust compliance programs to avoid enforcement actions. The proliferation of state privacy laws highlights the need for a comprehensive federal framework, though legislative prospects remain uncertain. Prisoner rights, sentencing, and criminal justice policy changes. A federal judge temporarily blocked the Trump administration from transferring 20 former federal death row inmates to the Supermax prison in Florence, Colorado, finding that the process likely violated their Fifth Amendment due process rights. The judge cited evidence that the outcome was predetermined by executive order and public statements, depriving inmates of a meaningful opportunity to challenge their redesignation. The ruling underscores the judiciary's role in safeguarding constitutional protections, even for those convicted of the most serious crimes. Legal analysts predict that the case may set important precedents for administrative decision-making and the limits of executive authority in the federal prison system. Disclaimer: the following content is for informational purposes only and does not constitute legal, financial, or medical advice. Do not treat any of the following anecdotal stories as advice. Daily Legal News Roundup, February 15, 2026. Office of Personnel Management orders termination of federal collective bargaining agreements. On February 13, 2026, the Office of Personnel Management, OPM, issued a directive instructing federal agencies to proceed with terminating collective bargaining agreements, CBAs, with federal unions, as mandated by 2 executive orders signed by President Donald Trump in 2025. This move comes despite ongoing litigation and several court injunctions that had previously delayed or blocked the implementation of these orders at certain agencies. The executive orders, citing national security under a rarely used provision of the 1978 Civil Service Reform Act, targeted more than a dozen federal agencies, including the Department of Defense, Department of Veterans Affairs, and Department of the Treasury. The orders collectively affect over 1 million federal workers, representing nearly 85% of the unionized federal workforce. While most agencies began terminating their CBAs after an August 2025 appellate court decision lifted a preliminary injunction, a smattering of agencies continued to recognize their unions due to ongoing court orders. The latest OPM memo, signed by Director Scott Cooper, directs all agencies covered by the executive orders to notify unions and bargaining unit employees of the termination of their contracts. The memo also includes a template for agencies to report monthly progress on contract cancellations and instructs agencies to update personnel files, cancel ongoing arbitration and unfair labor practice charges, and reclaim office space and resources previously allocated for union activities. Agencies are further directed to disregard union grievances and withdraw from ongoing negotiations where collective bargaining is being rescinded. Federal unions, including the American Federation of Government Employees, AFGE, and the National Treasury Employees Union, NTU, have condemned the directive as retaliatory and unlawful. AFGE President Everett Kelly described the administration's actions as unprecedented attacks on collective bargaining, vowing continued legal challenges until union rights are restored. NTU General Counsel Paresh Shah, in a filing with the U.S. Court of Appeals for the D.C. Circuit, argued that the OPM's memo demonstrates that the executive order's harm is certain and imminent, urging the court to issue a preliminary injunction. As of December 2025, OPM data shows a sharp decline in bargaining unit eligibility. Only 38% of the federal workforce remains in a bargaining unit, compared to 56% a year earlier. More than half of federal employees are now ineligible for union representation, marking a significant reversal in federal labor relations policy. The legal and political battle over federal collective bargaining continues, with unions pressing Congress to pass legislation restoring bargaining rights. The House passed the Protect America's Workforce Act in December, and unions are lobbying the Senate to take up companion legislation. Indian nationwide farm workers strike protests U.S.-India trade deal. On February 13, 2026, India witnessed a massive one-day nationwide strike by farm workers and trade unions protesting an interim trade deal between the United States and India. The strike, which reportedly involved up to 300 million participants, disrupted public services and manufacturing across the country. The trade deal, brokered earlier this year by President Trump and Prime Minister Narendra Modi, reduces American tariffs on Indian goods and eliminates Indian import taxes on American products. In exchange, India agreed to cease purchasing Russian oil and committed to buying $500 billion worth of U.S. goods, including energy. The deal also includes reciprocal tariff reductions, with U.S. tariffs on Indian goods dropping from 25% to 18% and the removal of a 25% penalty tariff previously imposed for India's Russian oil purchases. Protesters argue that the agreement will flood the Indian market with subsidized American agricultural products, threatening the livelihoods of millions of small farmers and local businesses. Amarjeet Kaur, General Secretary of the All India Trade Union Congress, stated, "Cheap American farm produce will be dumped in India, making it difficult for our farmers and small businesses to compete." Opposition parties and labor leaders also criticized the Modi government for advancing privatization of state-run industries and implementing new labor codes that, according to critics, erode worker protections and make union formation more difficult. Senior opposition leader Priyanka Gandhi Vadra accused the government of compromising farmers' interests under U.S. pressure and undermining workers' rights with the new labor code. The government, for its part, defends the trade pact as a means to expand exports, attract investment, and strengthen strategic ties with the U.S. Indian Trade Minister Piyush Goyal asserted that the interests of farmers in agriculture and dairy were protected in the deal. Nevertheless, the scale of the strike and the political backlash highlight the risks Modi faces in pushing market-oriented reforms ahead of key state elections later this year. India's $580 billion agriculture sector remains heavily protected, and previous attempts at reform have triggered large-scale protests. The current unrest signals that the government may face renewed challenges if it does not address the concerns of farmers and laborers. Supreme Court immigration docket, key cases and announcements. Immigration law is at the forefront of the U.S. Supreme Court's 2025-26 term, with several high-profile cases set for argument and decision in the coming months. The Trump administration's immigration policies, particularly those affecting deportation, asylum, and citizenship, are under intense judicial scrutiny. Birthright citizenship, Trump versus Barbara. Perhaps the most consequential immigration case this term is Trump versus Barbara, which challenges the legality of President Trump's Executive Order 14160. The order seeks to deny automatic citizenship to children born in the U.S. to parents who are neither citizens nor permanent residents, a direct challenge to the 14th Amendment's Citizenship Clause in the Immigration and Nationality Act, INA, of 1952. The Supreme Court will hear oral arguments on April 1, 2026. The administration argues that the 14th Amendment's phrase "subject to the jurisdiction thereof" requires at least one parent to have lawful, non-temporary status. Opponents, including legal scholars and civil rights groups, contend that the order contradicts both the constitutional text and long-standing Supreme Court precedent, particularly United States v. Wong Kim Ark, 1898, which affirmed birthright citizenship for nearly all children born on U.S. soil, regardless of parental status. Legal analysis suggests that the executive order also conflicts with the INA, which codifies birthright citizenship using language identical to the 14th Amendment. Scholars argue that Congress, not the President, has the authority to define citizenship, and that the executive order unlawfully disregards a clear congressional statute.
A decision is expected by early July 2026, with potentially far-reaching implications for immigration law and the rights of millions of U.S.-born children. Asylum and Judicial Review, Urias Orellana v. Bondi. In Urias Orellana v. Bondi, the court is considering the scope of federal appellate review in asylum cases. The key question is whether determinations of persecution are factual, and thus largely insulated from appellate review, or legal, and subject to de novo review. The outcome will affect the ability of asylum seekers to challenge adverse decisions by the Board of Immigration Appeals, BIA, in federal court. Oral arguments were held in December 2025, and the justices appeared inclined to treat persecution determinations as factual, which would limit appellate review and make it harder for asylum seekers to overturn BIA decisions. Asylum seekers at the border, Noem v. Al Otro Lato. Noem v. Al Otro Lato, scheduled for argument on March 24, 2026, addresses whether asylum seekers must physically cross the U.S. border to apply for asylum or if presenting themselves to U.S. officials in Mexico suffices. The case has significant implications for border policy and the administration's ability to regulate asylum claims. Removal of lawful permanent residents, Bondi v. Lau. Bondi v. Lau, set for argument on April 22, 2026, examines the rights of lawful permanent residents, green card holders, who are charged, but not yet convicted, of crimes that could lead to removal. The court will decide whether the government must have clear and convincing evidence of a crime before paroling a permanent resident into the U.S. and subjecting them to removal proceedings. A ruling against the resident could expand the government's power to detain and deport green card holders based on pending charges. Broader trends. The Supreme Court's immigration docket reflects ongoing legal and political battles over the scope of executive authority, the rights of non-citizens, and the interpretation of long-standing constitutional and statutory provisions. The outcomes of these cases will shape the future of U.S. immigration law for years to come. Fourth Circuit rejects DOJ motion in lawsuit against federal judges. In a highly unusual interbranch dispute, the U.S. Department of Justice, DOJ, sued the entire U.S. District Court for the District of Maryland and its 15 judges over standing orders that automatically stayed deportation proceedings for 2 days in habeas corpus cases. The Trump administration argued that these stays interfered with the president's authority to carry out swift deportations, framing the issue as judicial overreach. U.S. District Judge Thomas T. Cullen dismissed the lawsuit in August 2025. Calling it a novel and potentially calamitous attempt to pit the executive branch against the judiciary. Cullen found no legal basis for one branch of government to sue another in this context, and his decision avoided ruling on the merits of the standing orders themselves. After initially appealing, the DOJ sought to dismiss its own appeal as moot following modifications to the standing orders by the Maryland court. The DOJ also requested vacatur of the district court's opinion, a move that would have erased the precedent-setting loss. However, on February 11, 2026, the Fourth Circuit Court of Appeals denied both requests, stating, "The case is not moot," and reinstated the briefing schedule. This decision keeps Judge Cullen's opinion on the books and requires the DOJ to defend its appeal fully. Legal experts note that the Fourth Circuit's ruling preserves important precedent on the separation of powers and limits the executive branch's ability to erase unfavorable judicial decisions through procedural maneuvers. The case continues to highlight tensions between the executive and judicial branches over immigration enforcement and the scope of judicial review in habeas corpus proceedings. DOJ press releases and enforcement actions, February 13 to 15, 2026. The Department of Justice, DOJ, has been active in enforcement and civil rights actions in the days leading up to February 15, 2026. Notable developments include: Civil rights investigation into Lincoln Memorial University. On February 13, the DOJ's Civil Rights Division, in partnership with the Department of Health and Human Services, launched an investigation into Lincoln Memorial University, LMU, in Tennessee. The probe seeks to determine whether LMU's DeBusk College of Osteopathic Medicine discriminated against Jewish students by allegedly preventing them from completing exams during the spring semester.
The investigation is being conducted under Title VI of the Civil Rights Act and Section 1557 of the Affordable Care Act. DOJ officials emphasized their commitment to combating anti-Semitism and ensuring equal educational opportunities for all students.
LMU has stated it will cooperate with the investigation.
Harvard University sued over admissions documents. The DOJ filed a lawsuit against Harvard University for allegedly withholding race-related admissions documents. The case is part of ongoing scrutiny of affirmative action and race-conscious admissions policies at elite universities. Orlando tax preparers enjoined. The U.S. District Court for the Middle District of Florida issued a preliminary injunction against Orlando area tax return preparers for allegedly preparing fraudulent returns. The injunction bars the preparers from preparing returns for others pending further proceedings. Colombian robbery crew member pleads guilty. The last member of a transnational Colombian robbery crew pleaded guilty in Miami for his role in a $5 million jewelry theft ring targeting high-end retailers. Gang members convicted in Memphis. 2 members of the unknown Vice Lords gang were convicted by a federal jury in Memphis for racketeering murder, following a 1-week trial. Environmental settlement. Antero Resources Corporation agreed to a settlement with the DOJ and West Virginia's Department of Environmental Protection to resolve alleged Clean Air Act violations in West Virginia and Ohio.
These actions underscore the DOJ's continued focus on civil rights, financial fraud, organized crime, and environmental enforcement.
Supreme Court argument calendar and major cases for April 2026. The Supreme Court has released its April 2026 argument calendar, featuring several cases with significant implications for regulatory, civil rights, and corporate law.
Key cases include:
the court's April session will address issues ranging from the limits of federal regulatory power and the scope of the Fourth Amendment in digital surveillance, to corporate liability for international human rights abuses and the boundaries of patent law in the pharmaceutical industry.
Regulatory updates affecting financial institutions and enforcement trends.
February 2026 has seen continued regulatory shifts affecting financial institutions, FIs, with a notable trend toward fragmented enforcement and increased state-level activity.
Key developments include: federal pullback and state enforcement.
Federal agencies, including the Department of Housing and Urban Development, HUD, the Consumer Financial Protection Bureau, CFPB, and the DOJ, are retreating from certain examination frameworks, particularly those involving disparate impact oversight. HUD has proposed removing its disparate impact regulations under the Fair Housing Act, FHA, deferring to federal courts for interpretation. The CFPB and DOJ have withdrawn guidance on immigration status and lending decisions, clarifying that while immigration and citizenship status can be considered for legitimate creditworthiness reasons, they must not serve as proxies for protected characteristics such as national origin. Despite these federal changes, state attorneys general retain full authority to enforce disparate impact under the FHA, and states like New York have issued new frameworks for mortgage bankers, requiring geographic assessment areas and enhanced data reporting. The result is a fragmented enforcement landscape, with FIs facing compliance risks from multiple directions, including private lawsuits and aggressive state action.
CFPB funding and compliance changes.
The CFPB continues to operate after a federal judge ruled that its funding mechanism, drawing from Federal Reserve revenue, is constitutional. The Bureau received $145 million from the Fed for the first quarter of 2026.
However, the CFPB has discontinued its HMDA, Home Mortgage Disclosure Act, email alert service, requiring lenders to monitor the CFPB website directly for updates. HUD's disparate impact rulemaking.
HUD's proposed rule to remove its disparate impact regulations has drawn sharp criticism from state attorneys general and fair housing advocates, who argue that disparate impact remains a critical tool for combating housing discrimination and segregation. The proposal follows an executive order emphasizing equality of opportunity over outcomes and seeks to eliminate regulatory frameworks that impose disparate impact liability. Critics warn that the move will increase confusion, litigation, and non-compliance, particularly as state laws and private enforcement continue to recognize disparate impact claims.
Debanking and account closures.
High-profile litigation, including President Trump's $5 billion lawsuit against J.P. Morgan Chase alleging politically motivated account closures, has brought increased scrutiny to debanking practices. The Office of the Comptroller of the Currency, OCC, has released findings urging banks to ensure that account closure decisions are based on clear, objective risk factors rather than reputation or viewpoint. FIs are advised to review their policies and maintain robust documentation to withstand regulatory and judicial review. Credit card APR cap proposal. President Trump has revived a proposal for a 1-year, 10% cap on credit card interest rates. While not law, the proposal reflects growing political interest in consumer affordability and could influence future rulemaking and enforcement priorities. FDIC and NCUA updates. The FDIC has finalized amendments to deposit insurance signage requirements, with compliance delayed until April 2027. The National Credit Union Administration, NCUA, has released its 2026 supervisory priorities, emphasizing credit quality, interest rate and liquidity risk, and operational risk, including cybersecurity and fraud. The NCUA is also advancing a deregulation initiative to reduce compliance burdens on credit unions, though best practices recommend maintaining existing controls in anticipation of potential regulatory shifts. Legal market trends and the 2026 State of the U.S. Legal Market Report. The 2026 report on the state of the U.S. legal market, published by the Thomson Reuters Institute and Georgetown Law's Center on Ethics and the Legal Profession, paints a picture of record law firm profits amid growing structural risks. Key findings. Record profits and demand. The average law firm achieved 13% profit growth in 2025, with demand surging to its highest level since the global financial crisis. Worked rates grew by 7.3%, and smaller firms captured much of the growth as clients sought lower-cost alternatives. Rising expenses. Technology and talent costs are escalating rapidly, with firms investing heavily in AI and expanding headcount. This arms race is sustainable only if demand and rate growth continue. Business model tensions. Despite transformative technology investments, 90% of legal fees still flow through hourly billing, which may not reflect the value delivered. Buyer sentiment and forecasts. Corporate general counsels are signaling spending pullbacks, with net spend anticipation dropping to pandemic-era lows. Financial forecasts point to a possible contraction by mid-2026. Historical parallels. The current boom mirrors conditions preceding previous downturns, such as those in 2007 and 2021, with booming demand masking underlying instability. Strategic recommendations. The report urges law firms to use the current boom to modernize pricing models, strengthen client relationships, and deploy technology for measurable value. Firms that fail to adapt risk being caught unprepared for an inevitable market correction. Federal litigation filings in new district court cases, February 14 to 15, 2026. Federal court dockets for February 14 to 15, 2026, reflect ongoing trends in immigration, civil rights, and commercial litigation. According to Justia dockets and filings in ProPublica's habeas tracker, immigration-related habeas corpus petitions continue to surge, with more than 18,000 cases filed since January 2025, more than in the previous 3 administrations combined. California and Texas lead in detention challenges, with significant increases in Minnesota and other states experiencing immigration crackdowns. Recent filings include immigration habeas petitions, multiple cases filed in California, Florida, Maryland, and Massachusetts challenging the detention of non-citizens. Civil rights actions, cases alleging job discrimination, deprivation of rights under 42 U.S.C. Section 1983, and other civil rights violations. Commercial disputes, contract and tort actions, including marine cargo loss and legal malpractice claims. The volume and geographic distribution of filings highlight the ongoing impact of federal immigration enforcement and the continued importance of federal courts in adjudicating civil rights and commercial disputes. Civil rights and education enforcement actions. The DOJ's Civil Rights Division has intensified its focus on discrimination in education, as evidenced by the investigation into Lincoln Memorial University for alleged anti-Semitism. The probe, announced on February 13, 2026, is part of a broader federal effort to address rising anti-Semitism on college campuses since the October 2023 Hamas attacks on Israel. The investigation will examine whether LMU's DeBusk College of Osteopathic Medicine intentionally prevented Jewish students from completing exams, in violation of Title VI and Section 1557. The DOJ and HHS have emphasized that all students are entitled to learn in environments free from discrimination, and that anti-Semitism constitutes a violation of federal civil rights laws. This action follows a series of federal warnings to colleges and universities about their obligations under Title VI and reflects a sustained national focus on campus harassment and access concerns.
Corporate litigation and high-profile lawsuits. Trump versus Barbara, birthright citizenship. As discussed above, this case challenges the legality of President Trump's executive order restricting birthright citizenship. The outcome will have profound implications for constitutional law, immigration policy, and the rights of millions of U.S.-born children.
J.P. Morgan debanking lawsuit. President Trump's $5 billion lawsuit against J.P. Morgan Chase and its CEO alleges that the bank closed accounts for political reasons. J.P. Morgan denies the allegations, asserting that account closures were based on legal, regulatory, and risk considerations. The case has drawn national attention to the issue of debanking and the need for clear, objective standards in account closure decisions.
Monsanto versus Durnall, Roundup litigation.
The Supreme Court will hear Monsanto versus Durnall on April 27, 2026, addressing whether state law failure to warn claims regarding the weed killer Roundup are preempted by federal law. Bayer, which acquired Monsanto, argues that EPA-approved labels preclude additional state warnings. The outcome could affect tens of thousands of pending lawsuits and clarify the boundaries of federal preemption in product liability cases.
Hikma versus Amarin, pharmaceutical patent litigation.
Set for argument on April 29, 2026, Hikma versus Amarin addresses whether a generic drug maker can be sued for inducing patent infringement based on statements that its product is a generic version of a brand-name drug, even when the patented use is carved out of the generic's label. The case has broad implications for the pharmaceutical industry, generic drug competition, and the scope of induced infringement liability.
Cisco Systems versus Lopez, international human rights and corporate liability.
On April 28, 2026, the Supreme Court will consider whether the Alien Tort Statute and Torture Victim Protection Act allow private rights of action for aiding and abetting human rights abuses. The case arises from allegations that Cisco Systems aided the Chinese government's persecution of Falun Gong practitioners by providing surveillance technology. The outcome will shape the liability of U.S. corporations for alleged complicity in foreign human rights violations.
Geofence warrants and Fourth Amendment issues, Chaudhry versus United States preview.
The Supreme Court will hear Chaudhry versus United States on April 27, 2026. A case that could redefine the boundaries of digital privacy under the Fourth Amendment. The issue is whether the execution of a geofence warrant, which compels technology companies to provide data on all cell phones present in a specific area at a specific time, constitutes an unreasonable search.
Geofence warrants have become a common investigative tool, but courts are divided on their constitutionality.
The Fourth Circuit previously held that such warrants do not violate a reasonable expectation of privacy because users voluntarily share location data with technology providers. The Fifth Circuit disagreed, analogizing geofence data to cell site location information and warning of near-perfect surveillance. The Supreme Court's decision will have major implications for law enforcement, technology companies, and individual privacy rights. Pharmaceuticals and patent/generic drug litigation.
Hikma versus Amarin. As detailed above, the Supreme Court's decision in Hikma versus Amarin will clarify the standards for induced patent infringement in the context of generic drugs with skinny labels.
The case addresses whether statements outside the FDA-approved label, such as marketing materials describing a product as a generic version, can support liability for encouraging infringing uses.
The outcome will affect both the pharmaceutical industry and broader questions of secondary liability in patent law. Monsanto versus Durnall.
The Roundup litigation, now before the Supreme Court, centers on whether state law claims that Monsanto failed to warn about cancer risks are preempted by federal law.
The case is closely watched by both plaintiffs and the chemical industry, as it could resolve conflicting lower court rulings and determine the future of thousands of pending lawsuits.
International human rights and corporate liability, Cisco Systems versus Lopez. Cisco Systems vs. Lopez, also styled as Cisco vs. Doe, presents the Supreme Court with questions about the scope of the Alien Tort Statute, ATS, and the Torture Victim Protection Act, TVPA. Plaintiffs allege that Cisco aided and abetted the Chinese government's persecution of Falun Gong practitioners by providing surveillance technology. The Ninth Circuit allowed the case to proceed, holding that aiding and abetting liability is actionable under both statutes. The Supreme Court will decide whether these statutes permit private rights of action for aiding and abetting, with significant implications for corporate accountability in international human rights cases. State-level enforcement and attorney general activity. With federal agencies stepping back from certain enforcement roles, state attorneys general are increasingly active in areas such as fair housing, consumer protection, and financial regulation. States like New York have implemented new frameworks for mortgage bankers, and multi-state coalitions are challenging federal regulatory rollbacks, particularly those affecting disparate impact liability under the FHA. State AGs have also submitted formal comments opposing HUD's proposed removal of disparate impact regulations, arguing that such liability remains essential for combating ongoing housing discrimination and segregation. They warn that eliminating federal guidance will increase confusion, litigation, and administrative burdens for state agencies and housing providers. Recent civil litigation highlights. A review of recent federal and state court decisions reveals ongoing developments in areas such as copyright, antitrust, employment, and constitutional law. Copyright. The Ninth Circuit affirmed summary judgment for a defendant in a copyright action involving the use of a photograph as the basis for a tattoo, emphasizing the need to show substantial similarity in original expression. Antitrust. The Ninth Circuit clarified the limits of antitrust liability for refusal to deal and for injuries occurring outside the U.S., reinforcing the need for proximate cause and direct effects on domestic commerce. Second Amendment. California's ban on open carry in populous counties was successfully challenged, with the Ninth Circuit finding the law inconsistent with Supreme Court precedent. Civil rights. The Supreme Court reaffirmed the limited role of federal courts under the Anti-Terrorism and Effective Death Penalty Act, AEDPA, emphasizing deference to state court findings in habeas cases. These cases illustrate the dynamic and evolving nature of American civil litigation, with courts grappling with new technologies, evolving statutory frameworks, and shifting constitutional doctrines. Media and legal commentary. Leading legal news and commentary outlets, including On Labor, SCOTU's blog, Law and Crime, Thomson Reuters, Justia, and DOJ press releases, continue to provide in-depth analysis and reporting on these developments. Their coverage is essential for understanding the nuances and implications of ongoing legal disputes and regulatory changes. Video tags. Legal news. February 2026 legal update. Supreme Court cases.